All right, we are on the record in V-2021, Jackie Ayers versus Hitchcock Studios Incorporated. Could I get appearances of counsel starting with plaintiff?
Yes, good morning, Your Honor. My name is Chahak Gojia, and I represent the plaintiff, Jackie Ayers, on behalf of the estate of Ernest Ayers.
Good morning, Your Honor. My name is Julie Tedesco, and I also represent the plaintiff, Jack Ayers, on behalf of the estate of Ernest Ayers.
Good morning. And appearances for defense.
Good morning, Your Honor. Andre Enriquez, last name spelled E-N-R-I-Q-U-E-Z, appearing for the defendant, Hitchcock Studios, who's represented by Mr. Avery Hitchcock, will be with us on camera today.
Good morning, Your Honor. Laura Rodi, appearing on behalf of the defendant as well, last name R-O-D-I.
Good morning. And before we get started with our jurors, I was going to say do the people, but this is a civil matter. Does the plaintiff have any preliminary issues that we need to take care of?
Yes, Your Honor. We have a few housekeeping matters. We spoke with opposing counsel in a pretrial conference, and we agreed to pre-stipulate to some items of evidence, so we wanted to bring your attention to those. They will be the following. Exhibit 1, which is a headshot of Ernest Ayers taken in June of 2018. Exhibit 3, the contract between Ernest Ayers and Hitchcock Studios. Exhibit 8, a note left by Avery Hitchcock, the defendant, to Ernest Ayers. Exhibits 7 and 10, which are video evidence of Ernest Ayers doing 2 scenes on set of the movie Cobain. And exhibit 14, which are text message exchanges between Avery Hitchcock and someone named Barry. Your Honor, in addition to these, there are also a few items that were pre-admitted into evidence before today's trial that we've also stipulated to.
Could you slow down for just a moment, Ms. Tedesco?
Yes,
let me just make sure that my notes are correct. We have 1, the photograph of Ernest Ayers, 3, the employment contract, 8, the handwritten note, the videos in 7 and 10, the text message in 14.
Yes, Your Honor.
And then per stipulation, I believe we also had 2, 6, 12, and 13.
Yes, all of that is correct.
Okay, let me just make sure. So I think I'm going to do this by elimination rather than inclusion. So we have 4 is not yet admitted. 5 is not yet admitted. 9, 11, and then the depot transcripts and interrogatory responses.
Yes, Your Honor.
Okay, and I'm sorry, I didn't mean to interrupt, but I was not able to take notes quickly enough. So everything at this point is admitted except for those 4 exhibits that I just stated on the record.
Yes, Your Honor.
And so stipulated from the defense?
Yes, Your Honor.
Thank you, Ms. Rodi. So exhibits 1 through 14, with the exceptions of 4, 5, 9, and 11, will be admitted. Either party can display to the jury without asking leave of the court. So just you can do that during your presentation without asking. And then for 4, 5, 9, and 11, if there are admissibility issues, we'll take those up as needed.
Yes, Your Honor.
All right. I'm sorry to interrupt. Go ahead. Ms. Tedesco, anything else?
Yes, the plaintiff has one more request. Per a stipulation, we wanted to ask the court if it could read in a stipulation before you read in the jury instructions at the end of the trial. It's stipulation 18, which is found on page 9 of the record. If you'd like, I can read it to you now, or.
I have it in front of me. Any objection to me including stipulation 18 during the reading of jury instructions, defense?
No, Your Honor. We just also ask that exhibit 13, the stipulation number 15, also be read.
Stipulation 15 and 18. So stipulated, Ms. Tedesco?
1 second, I'm just reviewing. Yeah, that's no problem, Your Honor.
All right, so we will read both of those along with the jury instructions. Anything else, Ms. Tedesco?
That's it from the plaintiff, Your Honor.
And Ms. Rhodey, any housekeeping matters for defense?
Yes, Your Honor. I'd just like to point out that the exhibits that come in today have been pre-marked for identification. So we ask that the exhibits retain those numbers, and so they might come in out of order during trial.
Not a problem. Anything else from defense?
Yes, Your Honor. While we met and conferred, we also stipulated to one of the defense's motions in limine. Our stipulation is regarding, in this case, method acting will be at issue. Method acting is a technique that is employed by Hitchcock Studios, and the defense has a good faith belief that the plaintiff will argue that the decedent was asked to method act. And so prior instances of method acting in Hitchcock Studios productions has been stipulated as inadmissible.
So stipulated, Ms. Tedesco?
Yes, Your Honor.
All right, so we'll show that those are going to be excluded under FRE 404 by stipulation. Anything else from defense?
No, Your Honor. With that, we're ready for motions in limine.
And plaintiff ready for motions in limine?
Yes, Your Honor.
Let's discuss one last thing, and that is on the reading of the instructions and the two stipulations, 15 and 18. And if I forget while we're doing instructions, don't be shy about reminding me to read those instructions along, read those stipulations along with the instructions. Do counsel want me to pre-instruct the jury or post-instruct the jury? Do you have a preference, Ms. Tedesco?
Plaintiff has no preference, Your Honor.
Ms. Rhodey?
No preference, Your Honor.
All right, I will pre-instruct the jury that way that they don't get something really boring right at the end. Okay, plaintiff's motions in limine.
Your Honor, we have no motions in limine at this time.
Defense's motions, those are my favorite kind, by the way. Defense's motions in limine?
I'm sorry to disappoint, Your Honor, but we do have motions in limine. Your Honor, the defense has a good faith belief that the plaintiff will elicit statements from the decedent through the testimony of the plaintiff's witness or the plaintiff himself, Jack Ayers. In order to reduce the number of sidebars during trial, we ask for a pretrial ruling on which of those statements are admissible. And we have it broken down by 3 different conversations that I can walk through individually.
All right.
All right. Your Honor, the first conversation is a lunch that takes place involving the defendant's agent, Avery Hitchcock, and the witness, Jack Ayers, and the decedent, Mr. Ayers. These can be found starting on page 30 of the record, Your Honor.
Give me just a moment to get there.
Yes, Your Honor. And for
All right, got it.
For context, this conversation is generally about an offer by Mr. Hitchcock to Mr. Ayers for the role in Kurt Cobain.
Yes.
And during this conversation on page 30, lines 23 to 24, Mr. Ayers says, "I'm not a method actor. I act by finding the character's motivation, not by living by them." And then on lines 31, line through 2, "I'm a recovering addict myself." And page 31, line 3 through 4, "I can't use again." Your Honor, these are hearsay statements. And seeing as even though Mr. Ayers is a party opponent, he's only a party opponent when offered by the defense.
All right, and any response? Who's going to be arguing this? Ms. Tedesco?
Yes, Your Honor. Your Honor, these statements will not be considered hearsay because they will not be taken for their truth. We will not be using these statements in order to prove exactly what Ernest Ayers was saying, but rather in order to contextualize and to understand the party opponent statements on behalf of Avery Hitchcock. This goes to notice of Avery Hitchcock and knowledge that he knew that Ernest Ayers suffered from an addiction to heroin, which we believe and have reasonable belief that the defense will claim during their case that he did not know. So these statements go to the knowledge and the notice of the defendant of Ernest Ayers, and they are not to be taken for the truth of the matter asserted.
Ms. Rhodey, anything else before I rule?
With regards to these specific statements, Your Honor, submitted on prior arguments.
I'll allow the statements to come in for the purpose of showing awareness on behalf of defendant as to whether it's true or not. It would go to liability in terms of whether the defendant was aware of any type of condition that the plaintiff had and chose to encourage the plaintiff to take certain actions disregarding the prior drug use, or at least expression that there was prior drug use. All right, the second.
Your Honor, before I proceed to the second conversation, may I ask for limiting instructions whenever these statements are elicited?
Yes, and again, if I forget to give the limiting instruction, don't be shy about reminding me, and I'll be happy to do so at the time that the evidence is admitted.
Yes, Your Honor, understood. And then moving on to the second conversation, which takes place on June 5th. This conversation is again between the decedent, Mr. Ayers, and the witness, Jack Ayers. The conversation takes place when Mr. Ayers is in Los Angeles and Jack Ayers is in New York, and they're talking over the phone as Mr. Ayers is walking into his trailer. And I'll give Your Honor a moment to get to page 34.
Page 34. On which lines?
The lines are lines, page 34, line 23, and then it continues on to the top of page 35, line 1.
All right, and I have it.
So these statements, the particular statements the defense is seeking to exclude are with regards to Mr. Ayers telling Jack Ayers, there's a syringe on the table in my trailer. I'm looking at a syringe full of, it looks like heroin, and Avery must have put heroin in my trailer, and there's a note on a napkin.
May I respond?
Yeah, Your Honor, before, may I just state my grounds?
Sure, I'd like to hear the grounds before I hear the response.
Yes, Your Honor. We object to these statements as hearsay under 801 and 802, as well as speculation under 602.
All right, and yes, Ms. Tedesco, I'm happy to hear the response.
Yes, Your Honor. I'd like to take each argument by itself. So as for the hearsay grounds, the first portion of this statement that we intend to elicit is a statement made by Ernest Ayers as he's walking into his trailer and he's on the phone with his husband, Jack Ayers. As he's on the phone with Jack Ayers, he's describing exactly what he's seeing when he walks into his trailer. He describes seeing a syringe on the table, which he believes is full of heroin, and he describes seeing a note. Therefore, these statements fall under an exception to hearsay, 8031, a present sense impression. They were made contemporaneously at the exact moment that Ernest Ayers was seeing what was in front of him, and therefore they fall under this exception. As for the lack of personal knowledge portion of the argument, we intend to elicit with what we believe is in agreement with opposing counsel, that Ernest Ayers had a previous addiction to heroin. Therefore, he does have the ability to make a reasonable belief that he saw heroin in his trailer because of this previous addiction. As for the last portion of the argument, Avery must have put heroin in my trailer. This goes to Ernest's state of mind, and it should not be taken for the truth of the matter asserted. He believed that this heroin, in conjunction with a note left for him by the defendant, which the defendant does admit to writing in his deposition for this case, meant that the defendant wanted him to use heroin in order to better play his role in this case, his boss in this case.
Why is Ernest's state of mind relevant?
Ernest's state of mind is relevant because this case is about negligence and how Ernest's death was subsequently caused. The defense has raised an affirmative defense in this case. So if Ernest believed that his boss was instructing him to use heroin, which he did by eliciting this testimony, then it lessens his liability. So his knowledge and his belief that his boss was instructing him is extremely relevant to this case.
In terms of the affirmative defense of contributory or comparative negligence?
Yes, Your Honor.
All right. Anything else, Ms. Rhodey?
Yes, Your Honor. The defense is willing to concede that there is a present sense impression in parts of these statements. For example, when Mr. Ayers walks into the trailer and says there is a syringe on the trailer and that there is a note on a napkin, those will fall under present sense impression. However, the defense takes issue particularly with the statements that say, I'm looking at a syringe full of, it looks like heroin, and Avery must have put heroin in my trailer. Those do not fall under the present sense impression exception, Your Honor.
Your Honor, may I be heard?
No. Again, I'll be happy to give a limiting instruction upon request, but I agree with plaintiff. If the issue is comparative negligence, then whether, and again, I'm not accepting these as facts, but in terms of the argument as to the relevance of these statements, the fact that the decedent believed at the time of taking whatever substance that that was the wish of the director and felt pressure to do so would be relevant in terms of comparative negligence. As far as the speculation as to it looks like heroin, I think that goes to weight and not admissibility. Again, presuming that the foundation is laid that the decedent was a previous heroin user, I think that that would be sufficient for the evidence to be admissible, and then anything else can go to weight, not admissibility. So again, if I get the request for the limiting instruction, I'll be happy to give it at the time the statement comes in, but I will admit the statement and it will be largely admissible for the truth of the matter asserted, except for the Avery must have put heroin in my trailer.
Understood, Your Honor. And then finally, the last conversation is a telephone conversation on June 19th, which takes place again between the decedent, Mr. Ayers, and Jack Ayers, the witness. And in this conversation, the decedent claims to have started using heroin on June 5th. The page that I'm referring to, Your Honor, on the record is page 36.
I have it.
The statements that we seek to exclude are with regards to Mr. Ayers' statement that it was Avery telling him to use heroin, so he injected the syringe and felt the high within minutes. Your Honor, these statements again are hearsay under 801 and 802, as well as also speculative, because the statements are actually that he thinks that Mr. Hitchcock is telling him to use heroin.
Response?
Your Honor, we actually pre-stipulated that we're fine with this statement not coming in, so we have no objection.
All right, so
Thank you.
plaintiff is not seeking, so I don't need to rule. Plaintiff has agreed not to try to admit that statement. Any other motions in limine from defense?
Yes, Your Honor, one final motion, not with regards to any statements by Mr. Ayers, but instead we seek to exclude a description of Mr. Ayers' body when his spouse, Jack Ayers, found him on June 21st. We think that these statements are inadmissible under Federal Rule of Evidence 403, as they are cumulative and unduly prejudicial to the defendant. The information about Mr. Ayers' state can be addressed using Mr. Ayers' autopsy report.
And what is it specifically about Jack Ayers' description of the decedent's body that you feel is cumulative?
Yes, Your Honor. As an offer of proof on page 37, lines 18 through 19.
Yes.
We believe it's cumulative that to describe Mr. Ayers' state, that he looked purple, that he had no pulse. The fact that Mr. Ayers, all these statements go to the fact that Mr. Ayers had passed away, and all that information is really presented through the autopsy report. We feel that through Mr. Ayers' testimony today, these statements will be unduly prejudicial because they call on the jurors to make a decision based on emotions, not the evidence.
All right, response?
Your Honor, in terms of the needlessly cumulative argument, it's for something to be cumulative, it needs to be needlessly cumulative and a waste of the court's time. This testimony that will be elicited is not available on the autopsy, therefore it's not cumulative. In terms of the 403 argument, for something to be excluded under 403, the prejudicial effect must substantially outweigh the probative value. This witness will describe how he found his husband's body, and we have reason to believe that opposing counsel may elicit testimony that the decedent was not using heroin until less than 5 days before his death. This witness will testify how he found next to his husband's body a spoon and a syringe filled with heroin, which is the same way that the decedent utilized heroin in the past. And he will also describe the note left next to the decedent's body that was left for him by the defendant. The way that the body was found is extremely probative in this case, and the risk of prejudice is minimal because we're not showing any images of the body, we're not showing the wounds, we're not showing the actual physical condition of the body or anything like that. Because of this, the prejudicial value does not, or the prejudicial effect does not substantially outweigh the probative value.
When you say it is probative, probative of what?
It's probative for the jury to understand how the decedent died, because as I said previously, we believe the defense will call into question the timing in which the heroin use was utilized. Therefore, it's probative for the jury to understand the state in which Ernest Ayers' body was found.
Ms. Rhodey?
Yes, Your Honor. We believe that, as Your Honor was suggesting, these statements are irrelevant and are really just an attempt to seek sympathy from the jurors and calling on them to make an emotional decision. And that's why it should be excluded under Federal Rule of Evidence 403.
Is it correct that the defense will be calling into question the timing of the heroin use and or overdose?
Yes, Your Honor, but these statements don't go to the timing of the heroin use. The fact that there was a syringe on the table, which the defense is not objecting to as a clarification, doesn't go to the timing of Mr. Ayers' heroin use. In fact, the autopsy does, and that will be admitted.
Well, I think that the fact that a syringe is found near the decedent's body, and again, if you're not objecting, I don't know why we're talking about it. What part of the description that Jack Ayers is going to give are you objecting to?
Your Honor, we're objecting specifically to the description of Mr. Ayers on the couch. What the evidence that Mr. Jack Ayers found while entering into the apartment is not objectionable, but the description of Mr. Ayers' body is what the defense is objecting to here.
And what parts of that description?
Your Honor, would be the statements that I was referring to with regards to him looking purple, having no pulse, having vomit in his mouth. All of these statements are just creating an image in the minds of the jurors that will really call on them to make an emotional decision.
All right. The motion is denied. I think that in terms of the jury reaching an emotional decision, I see that there is some danger of that, but I don't see that the probative value is substantially outweighed. If there wasn't a timing issue, then I would say that this tends to go towards damages and not towards liability. But since there is a timing issue, the condition of the body, the way it looks at the time it's discovered, what drug paraphernalia may or may not have been nearby, is all at least somewhat probative on the issue of when the use took place and when the decedent passed. The fact that the medical examiner made findings that were more specific, again, go to weight and not admissibility, but I don't find that it is so cumulative that it should be excluded. Now, if the description gets drawn out, feel free to renew the objection, Ms. Rhodey or Mr. Enriquez, whoever's doing the cross-examination of that witness. And I'll be happy to take a look at the time if I feel that it is unduly cumulative or unduly prejudicial.
Understood, Your Honor.
All right, anything else from the defense on motions in limine?
No, Your Honor, the defense is ready for trial right on time.
Excellent. Let me let our bailiff know. It's usually at awkward moments like this where I give a lesson on the Great Seal of the state of California, but I don't have it behind me anymore. But my bailiff has told me that that we do have all our jurors. So I think it's just a matter of giving them some instructions and bringing them in.
Hey, other jurors, if you could turn off your camera, please.
Your Honor,
All right.
once you're ready, we have everybody here and the courtroom is yours. Thank you, Your Honor.
Thank you, Mr. Bernstein. Okay, if we could have our I think we're set with turning off cameras now. So we're back on the record in V 2021 Ayers versus Hitchcock Studios Incorporated. Our attorneys have previously made their appearances, but I'll give them a chance to introduce themselves to the jurors, and we'll start with plaintiff's counsel.
Good morning. My name is Chehek Ojia, and I represent the plaintiff in today's case, Jack Ayers, on behalf of the estate of Ernest Ayers.
Good morning. My name is Julie Tedesco, and I also represent the plaintiff in this case.
Good morning. My name is Andre Enriquez, and I represent the defense, Hitchcock Studios, represented by Mr. Avery Hitchcock today.
Good morning, Laura Rohde, appearing on behalf of the defendant as well.
We'll get straight to opening statements. I thank the jurors for their service, and we'll start with openings by plaintiff.
May I proceed, Your Honor?
Yes.
When they're young and unknown, they have to listen to you. These were the words of Avery Hitchcock, one of the most well-known Hollywood directors. To find Kurt, You have to let Ernest go. These were Hitchcock's words when he manipulated Ernest Ayers, an unknown actor waiting for his big break, into using heroin. Avery Hitchcock, CEO of the defendant, Hitchcock Studios, handpicked an unknown, vulnerable actor that he knew had an addiction to heroin, supplied him with heroin, manipulated him into using it, and did nothing as he faded away right in front of him. That is what caused Ernest Ayers to die of a heroin overdose. Members of the jury, thank you for being here. My name is Julia Tedesco, and I, along with my co-counsel, Jehek Gojia, represent the plaintiff in this case. Now, some of you may be wondering, how could the defendant be responsible for Ernest's overdose if he didn't physically inject Ernest with heroin himself? But members of the jury, this is not a criminal case. It's not a murder case. This is a civil case. And at the end, the judge will instruct you that the defendant had an obligation to use reasonable care to keep its employees safe. Now, we will prove to you that it is more likely than not, which is our burden in this case, that the defendant's negligence through the actions taken by its CEO, Avery Hitchcock, contributed to Ernest Ayers' death. Today, you'll hear some names that may or may not sound familiar to you. Kurt Cobain, the lead guitarist and singer of the 90s band Nirvana, was famously addicted to heroin and died very young. This case is about his biopic, Cobain, directed by Oscar-winning movie producer Avery Hitchcock. But I'd like to take some time to talk to you about someone that you might not know, Ernest Ayers. This was Ernest Ayers. His husband, Jack, will tell you of Ernest's dreams of becoming an incredible actor. Ernest worked hard to support his family by working side jobs and doing off-Broadway shows so he could afford to pursue his career. Now, in 2016, Ernest suffered from an addiction to heroin, a disease that took control of his life, almost costing him his career and his marriage. But Ernest's sobriety was something that he worked toward, something that him and his husband, Jack, celebrated every single day. That was until one day, Avery Hitchcock sought to exploit that addiction for his own personal gain. You see, members of the jury, Avery Hitchcock famously uses unknown actors. In his own words, when they're young and unknown, they have to listen to you. Avery Hitchcock took Jack and Ernest to an expensive restaurant and offered Ernest the role of a lifetime on the spot to play Kurt Cobain in a movie about his life. But the evidence will show that Avery Hitchcock already knew that Ernest had a substance abuse problem, and he wanted Ernest to use again here. You see, Avery Hitchcock asked Ernest to use what's called method acting in order to play his role as Cobain. And you'll learn that for any reasonable person, method acting just means staying in character when the cameras stop rolling. But for the defendant, this meant actually living life just like the character. The very first day on set, Avery Hitchcock tortured Ernest with 62 takes of the same opening monologue over and over again, never telling Ernest what he was doing wrong. And at the end, Hitchcock stormed off the set and yelled to Ernest, "We tried it your way. Now, we try it my way." Later that day, Ernest returned to his trailer to find a syringe filled with heroin, a note from the defendant telling him that to find Kurt, he had to let Ernest go, and an instruction to call a phone number. a phone number, members of the jury, that you will learn belonged to the now missing drug dealer, Barry, hired by Avery Hitchcock. Ernest was in disbelief of what Hitchcock was asking of him. He was faced with an impossible choice. So Ernest returned to set later that day and reshot that same opening monologue in one take, take 63. This time, and only then, was Avery Hitchcock finally satisfied, because the evidence will show that Ernest was high on heroin. Members of the jury, you will have the opportunity to see both of these performances and compare them to yourself. Now, the defense is going to claim that Avery Hitchcock had no idea that Ernest was on heroin. But you'll watch these performances in the 63rd take, and you'll see that Ernest looked different, despite not wearing any makeup. And he acted different. You'll see in this take that Ernest looked exhausted. He was staring off into space, scratching at his neck and slurring his words. And you'll hear from Ernest's co-actor, Chandler Matz, how Ernest's symptoms, clear signs of heroin use, persisted. And you'll also learn that Chandler Matz told Avery Hitchcock he believed Ernest was seriously ill, that Ernest might be using heroin. Members of the jury, when you hear that testimony, I want you to ask yourself, what would a reasonably careful director do? Would they maybe get the lead actor in their film some help? But Avery Hitchcock's only reaction was to say, Kurt Cobain did heroin. And the defendant's only question, how does he look on camera? No, members of the jury, Avery Hitchcock didn't get Ernest help. In fact, the day before he died, Avery Hitchcock said to Ernest, just a little while longer, you are Kurt. Powerless against Avery Hitchcock and powerless against the effects of heroin, when Chandler Matz told Ernest he didn't need to do this to himself, Ernest looked directly at Avery Hitchcock and said, yes, I do. The very next day, Ernest's husband found him dead in his apartment, next to a syringe and a spoonful of heroin, and that note from Avery Hitchcock, telling him that to find Kurt, he had to let Ernest go. Now, on behalf of our client, my co-counsel and I would like to thank each and every one of you for your service, for doing your civic duty. A grave injustice has occurred, and only you can right that wrong. So at the end, after hearing all of this evidence, we will ask you to find that Hitchcock Studios, through the actions taken by its CEO, Avery Hitchcock, negligently caused Ernest Dyer's death. Thank you.
Thank you, Ms. Tedesco. Is the defense giving opening at this time or reserving?
At this time, Your Honor.
Mr. Enriquez, anytime you're ready.
At home, on a couch, and behind a closed door, that's where Mr. Ernest Ayers spent his last moments. Unable to wait for his husband, who was on his way to help, he chose to inject himself with heroin in the privacy of his own home and away from the prying eyes of anyone who could stop him, because he could not handle the stress of his newfound success. Members of the jury, what happened to Mr. Ernest Ayers on June 21st was absolutely awful. And our hearts go out to Jack Ayers and his entire family. However, this is a case about a young man haunted by a history of heroin addiction, an addiction that he could not control when he landed the role of a lifetime playing a heroin addict. At home, on a couch, and behind a closed door, Mr. Ayers made a terrible decision, but Avery Hitchcock and Hitchcock Studios could not predict or prevent his overdose because you simply cannot prevent what you cannot see. As jurors in this case, the issue for you to decide is whether Hitchcock Studios acted negligently in regards to Mr. Ayers' death. As the judge will instruct you, in order for the plaintiff to win this case, they must prove that more likely than not, Hitchcock Studios failed to act reasonably to prevent harm from coming to Mr. Ayers, and that harm and that failure caused his death. The plaintiff will ultimately fail in this burden, however, because the evidence instead will show two things. First, that Hitchcock Studios could not reasonably have foreseen Mr. Ayers' heroin overdose. And second, that it was actually Mr. Ayers' own poor decisions which led to his death. So let's take a look at the first thing the evidence will show, that Hitchcock Studios could not reasonably have foreseen Mr. Ayers' overdose. But before we go any further, I would like you to meet the person behind Hitchcock Studios. Mr. Hitchcock, could you please turn on your camera? Members of the jury, this is Avery Hitchcock. Mr. Hitchcock knows what it means to be an unknown in Hollywood. At a young age, he moved to Los Angeles and took a job at the very bottom of the pecking order, writing scripts until one day he got his big break. After years of hard work, he was finally able to open his own studio, Hitchcock Studios, in 2010. And today he's able to give the same great opportunities he himself was given to others. Thank you, Mr. Hitchcock. One of those unknown actors who received such a great opportunity was Mr. Ernest Ayers. In 2018, Mr. Hitchcock is in pre-production for a biopic about Kurt Cobain, the heroin-addicted lead singer of the 1990s blockbuster rock band Nirvana. Mr. Hitchcock sees Mr. Ayers in a play off Broadway, and he knows immediately that he has the talent, the look, and that tortured artist affect that's perfect for the role. Mr. Ayers recognizes this himself, and he agrees to take the part. Fast forward a year later, and filming for Cobain has started, but the first day, it's not going well. Mr. Ernest Ayers is struggling with that first scene. So Mr. Hitchcock pulls him aside to ask what's wrong. His response? He's nervous to shoot his first big scene in his first big movie, which is understandable. He wanted to be perfect. And after a few nights sleep, he comes back and he does nail that scene. He nails Kurt Cobain. In fact, for the next 2 weeks, he comes in every day and knocks it out of the park. And as the evidence will show today, when you're playing Kurt Cobain, knocking it out of the park means that your work is looking and sounding like a heroin addict. For the next few days, Mr. Ayers came to set looking like he was exhibiting symptoms of addiction. He was tired, he was out of it. He was scratching himself and clutching his stomach. But Mr. Hitchcock will testify that this behavior didn't raise any red flags because Mr. Ayers was acting like he was supposed to be acting. Members of the jury, he was coming in every single day, knowing his lines, sharing his scenes, playing a heroin addict. Now, it's undisputed that Mr. Ayers used heroin and that he died from an overdose of it. But that overdose, it didn't occur on the set of Cobain. It occurred in the privacy of his own home and behind a closed door, which leads me to the second thing the evidence will show, that it was actually Mr. Ayers' own poor decisions which led to his death. As Jack Ayers will be forced to admit today, it was actually stress that caused Mr. Ayers' first encounter with heroin in 2016. He'll tell you that it took a village to get him back on track. But Mr. Ernest Ayers chose to leave that entire support system behind to shoot this film, a film he knew was about a heroin addict who died from that addiction, and a film he signed onto without considering the triggering effects that it would have on him. Today, you're going to hear from Chandler Matz, a veteran actor of many Hitchcock films. Mr. Matz will tell you that despite sharing all of his scenes with Mr. Ayers, he noticed that he wanted to be perfect in his role. As the evidence will show, That strive for perfection, coupled with the stress that followed, is what actually caused Mr. Ayers' death and caused him to fall back on a familiar crutch, a heroin addiction. And it was an addiction that he hid well from everyone. You'll also hear from Ms. Delaney Gold Diamond, Mr. Ayers' talent agent and good friend. Ms. Gold Diamond is the only person in this case today who saw Mr. Ayers in 2016 while he was using heroin and in 2019 on the set of Cobain. She witnessed his heroin symptoms at their worst. However, despite witnessing those symptoms in 2016, when she was with him in 2019 on the set of Cobain and for a few hours afterwards, not once, and this occurred a few days before he died, not once could she identify signs of heroin use or concerning behavior. That's because members of the jury, the facts will show that Mr. Ernest Ayers was the only person who could have known what would put his sobriety at risk and how much stress he could handle. Because at the end of the day, it was only Mr. Ayers who sat on that couch, filled that syringe, and injected that last dose into his body. Common sense tells us that you cannot prevent what you don't know. Avery Hitchcock and Hitchcock Studios simply could not have prevented Mr. Ayers' death because they couldn't have known. It was Mr. Ernest Ayers who, at the end of the day, made the dangerous choice to use heroin alone, at home, and out of sight. That's why, at the end of this trial, my co-counsel is going to come before you and ask you find the only verdict in line with that same common sense, a verdict in favor of Hitchcock Studios, finding them not liable.
Thank you, Mr. Enriquez.
Good morning, everyone. At this time, we now recommend that everyone switch to gallery view. That can be found in the upper right-hand corner of your Zoom screen. Click on View in Gallery. If you do that, and then you see a lot of black boxes with some names, hover over one of those boxes. There should be a blue button in the upper right-hand corner with 3 dots. Click on that, and then there should be a Hide Non-Video Participants button. Go ahead and click that, and then you should only see 6 videos. If you have any questions, send me a chat.
Thank you, Mr. Capezius. We'll give our jurors just a moment to deal with technology, and we'll get started with the plaintiff's case in chief. I don't see any messages popping up in the chat, so I'm going to presume that everything has gone just fine. We'll get started with the plaintiff's first witness.
Yes, Your Honor. The plaintiff calls Chandler Matz to the stand.
And we will consider the witness sworn. And Ms. Goja, you can begin your direct examination.
Good morning. Could you please introduce yourself to the jury?
Yes, I'm Chandler Matz.
What do you do for a living, Mr. Matz?
I'm an actor. I've been in more than 50 movies and TV shows.
Have you ever played the lead in a movie or TV show before?
No, so I'm what Hollywood calls a character actor, which means that I don't typically get lead roles, but I do get a lot of work.
Now, I want to talk about why we're here today. Were you part of the movie Cobain?
Yes, I was.
Who produced and directed that movie?
Avery Hitchcock at Hitchcock Studios.
And have you worked with Mr. Hitchcock before?
Yes, 2 times before Cobain.
And what was Cobain about?
Cobain was a movie about the life and death of Kurt Cobain, the lead singer of Nirvana. And if you don't know, Nirvana was a really popular band in the 1990s, and Kurt Cobain was known for his heroin addiction before his tragic death.
Now, who was cast to play Kurt Cobain in that movie?
Ernest Ayers was.
Had you heard of Ernest Ayers before Cobain?
No, Ernest Ayers was unknown at the time.
Now, how often were you on set while filming Cobain?
I was on set for about half the time that they were filming.
In your experience, is it common for Avery, or Mr. Hitchcock rather, to ask someone unknown to play the lead role in a movie?
Yes, it's actually very common. Avery always casts unknowns as the lead. He says when they're young and unknown, they have to listen to you.
Have you ever heard Mr. Hitchcock talk about method acting?
Oh yeah, Avery's a big fan of method acting. He calls it the method.
What is the method?
Well, it's like Avery always says, you need to lose yourself in the role. You need to be that person, live as they live.
Now I want to talk about that very first day of shooting. That was being shot, what was being shot rather on the first day?
The first day of shooting was on June 3rd. So we were shooting the opening monologue for the movie. It was just supposed to be Ernest on screen talking straight into a camera for about a minute.
And how'd that monologue go?
It was pretty uncomfortable. Avery made Ernest reshoot the scene 62 times and it took hours.
I'm showing you what's already in evidence as exhibit 7. What is this?
This is the 60-second take that we were talking about.
I'm going to play the video for the jury.
I've been told an artist is in constant need of a tragedy to fully express their work, but I'm not an artist. And when I say I in a song, that doesn't necessarily mean that person is me, and that doesn't necessarily mean I'm a storyteller. It means whoever or whatever you want it to, because everyone has their own definitions of specific words. And when you're dealing in the context of music, you can't expect words to have the same meaning as in everyday use of our vocabulary, because I consider music as art. Was that good? Was that good direction? Do you want me to take it anywhere else?
In your career as an actor, Mr. Matz, is 62 takes for a single scene typical?
It's practically unheard of, especially for a scene that was as simple and straightforward as that one.
Did Mr. Hitchcock give Ernest any direction on how to improve?
No, Avery didn't give Ernest any specific feedback. Ernest kept asking, but all Avery kept saying was, "That's not Kurt Cobain, do it again."
Did the defendant say anything else about needing 62 takes?
He looked at Ernest and he said, "We tried it your way. Now we try it my way."
Did they reshoot that first scene?
Yeah, we planned for a week later, but instead we shot it just 2 days later on June 5th.
Did you watch them film that take?
I did, yeah.
Was Ernest's performance 2 days later different than it was in the previous 62 takes?
It was very different.
Now I'm going to show you what's already in evidence as Exhibit 10. In a second. There we go. What is this, Mr. Matz?
This is the 63rd take from June 5th that we were talking about.
I'm going to play it in its entirety now.
Been told an artist is in constant need of a tragedy to fully express themselves, but I'm not an artist. And when I say I in a song, that doesn't necessarily mean that person is me, and that doesn't necessarily mean I'm a storyteller. It means whoever or whatever you want, because everyone has their own definition of specific words. And when you're dealing in the context of music, you can't expect everyone to have the same meaning as in everyday use of our vocabulary, because I consider music as art.
Mr. Matz, how did the defendant respond to Ernest's performance in that 63rd take?
Avery was thrilled. He slapped Ernest on the back and he said, "That's the one."
Can you describe for the jury what Ernest looked and behaved like when he was off camera that very same day?
The exact same as you just saw in that video.
And how was his appearance on set after that?
Ernest looked awful for the next 2 weeks, sometimes even worse than he looked on that day when we reshot the scene, June 5th. His face was flushed. He had low energy, vacant eyes. He lost weight. He was scratching at his arms, his chest, his neck. He basically stopped talking during all of the breaks.
Did he still come into work every day?
He came in, but he was late some days.
Can you explain to the jury how Mr. Hitchcock manages scheduling on the set of Cobain?
Yeah, he runs a tight ship. He's a stickler for timeliness. Everything and everyone has to be on time.
And from what you saw, how did Mr. Hitchcock react to Ernest being late to work?
Honestly, Avery never said anything to Ernest about it. He didn't seem to mind that he was late.
And Mr. Matz, when you saw Ernest looking awful, what did you think?
I was really concerned. I thought he was using drugs, and given the fact that he was scratching himself, that it was probably heroin.
Objection, Your Honor. Speculation.
Do you want to be heard?
Yes, Your Honor.
Ms.
This is
Goja?
yes, Your Honor. This is based on his rationally based perception.
With the foundation that's been laid so far, objection sustained, and members of the jury, you'll disregard that testimony.
Your Honor, may I request a sidebar?
Yes. And we are,
We'll move the jury, Your Honor, and let you know when they're in their own room.
thank you. And members of the jury, just so you understand, there will be a few things that I have to discuss with the attorneys outside your presence. And while Mr. Capesius gets your breakout room ready, we'll try to keep these minimal and short, but we'll discuss a couple of things and bring you back as soon as I've made some decisions.
Your Honor, I think you're clear.
All right, so we are outside the presence of the jury. And I think I understand the objection. So Ms. Goja, why don't I hear from you since you requested the sidebar?
Yes, Your Honor. I wanted to give an offer of proof and I didn't want to do it in front of the jury. As an offer of proof, Mr. Matz has actually been on Hollywood for a number of years and has witnessed other people around him use drugs and specifically heroin. He's familiar with the use and what the symptoms look like. And moreover, Your Honor, we're not necessarily using this for the truth that Avery was 100, or Ernest rather, was 100% on heroin, that he's definitively saying this. We're actually, Your Honor, Mr. Matz is going to testify that he had this belief and then relayed this belief to the defendant, who was then on notice that somebody on that set believed as early as June 5th that Mr. Ayers was using heroin.
Mr. Enriquez.
Your Honor, what opposing counsel just posited lacks foundation. They have not laid any foundation under FRE 602 that Mr. Matz is aware of heroin use in the industry, that he knows what it looks like, in such a way that he would be able to testify as to how Mr. Ernest Ayers is appearing on set in the way that this line of questioning calls for.
All right. Anything else, Ms. Goja?
No, Your Honor. Again, this witness's rationally based perception. We can lay that foundation, but we're not using this to prove the truth of the matter asserted. We're just using this to show that the defendant was on notice because of this specific concern.
All right. I'm going to stick with my previous ruling. However, Ms. Goja, with that offer of proof, if this witness is going to testify that he spoke with Avery Hitchcock and told Avery Hitchcock, I think because of this behavior, that the decedent is using heroin, that can come in without further foundation. But if you're going to bring in something where he's giving that impression to the jury as opposed to just the statement that he made to put the defendant on notice, I am going to require a lot more foundation before you can get that opinion in. Make sense?
Yes, Your Honor.
Are we ready to proceed?
Yes, Your Honor.
And Ms. Goja?
Your
yes,
Honor, we'll bring the jury back in first.
Thank you, Mr. Capesius. And Mr. Capesius, am I pronouncing that correctly?
It's actually capacious, but that's
Capacious.
as good of a get. Yeah, you're close. Okay, Your Honor, looks like we have all the jurors back.
Members of the jury, thank you for your patience. Ms. Goja, your witness.
Mr. Matz, when you saw Ernest looking awful, did you do anything about it?
Yeah, of course. So on either June 10th or 12th, I went to Avery's trailer straight away, and I told Avery that I thought Ernest was using heroin.
And when you told Avery that you thought Ernest was using heroin, what did he say to you?
He said, well, Kurt Cobain did heroin.
And how did you respond to the defendant saying, well, Kurt Cobain did heroin?
I told him that Ernest looked seriously ill. And Avery just said, well, how does he look on camera?
After your conversation with Mr. Hitchcock, did anything about Ernest's behavior and appearance on and off camera change?
No, if anything, he was getting worse.
Now, I want to shift gears and talk about June 20th, 2019. Did you see Mr. Hitchcock speak to Ernest on that day?
I did. It was in between takes. Avery walked up to Ernest and Avery said, just a little bit longer, you are Kurt.
Did you speak to Ernest at all on June 20th?
I did later. I was still really concerned that he was doing heroin.
And what did you say to him?
Well, I pulled him aside and I said, you don't need to do this to yourself.
And what did Ernest say back to you?
Objection, Your Honor. Hearsay.
Ms. Goja?
Sidebar, Your Honor.
All right.
Sorry, Your
We'll
Honor.
we'll take one sidebar. Mr. Capacious?
Your Honor, before we move them, would you mind telling the jurors, I think some of them didn't understand what was happening. Would you tell them where they're going?
Oh, yes. So members of the jury, I apologize. I think some of you got moved before I explained this last time. Every once in a while, the lawyers and I will have to work out a legal issue that we have to do outside your presence. So we got to shift you away to a different room for a little while and then bring you back after I've made the decision on the legal ruling. I'll try to keep these to a minimum, and we'll bring you back as soon as possible.
Jurors, if you want to do it yourself, you can move yourself to the room named jury. Otherwise, we will start moving you on our own. Thank you.
Okay, Your Honor, the jury is out of the room.
Thank you so much. And Ms. Goja, help me out with this statement.
Yes, Your Honor. As an offer of proof, the witness is going to say that Mr. Ayers, the decedent, looked directly at Avery Hitchcock and said, yes, I do, in response to Mr. Matt saying, you don't need to do this to yourself. Your Honor, this goes directly towards the context and the state of mind of the decedent the day before his death. He believes that Avery Hitchcock is making him do something, and that's the reason why he's doing it. And as we discussed in motions in limine, they are asserting an affirmative defense. So it goes directly to the level of his liability in today's case.
Mr. Enriquez?
Your Honor, the plaintiff is using the statement to demonstrate that Mr. Ernest Ayers' belief is true, which is explicitly not permitted under 803.3, then existing state of mind exception to hearsay.
All right. So a couple things. First, Ms. Goja, I'm gonna have you lay some more foundation. I am gonna allow this for the stated purpose that it shows Mr. Hitchcock's awareness that the decedent felt that he had to do this. But while we have the jury out, are there any other statements that you're intending to bring out of the decedent that we didn't address in motions in limine so that we can avoid excusing the jurors anymore? With this
None from
witness?
us, Your Honor. This witness, we've got 2 more questions for him and then we'll let him sit down or be cross-examined rather.
All right, then, Mr. Enriquez, anything else that you think that we can take up with this witness outside the presence of the jury to maximize the productive use of their time?
No, Your Honor, I'd just like to point out that conversations between Mr. Ayers and Mr. Matz, Mr. Hitchcock isn't aware of the content of those conversations. And unless opposing counsel, again, lays the foundation that in some way or form that he did become aware of those conversations, we would just like to highlight the relevance of those interactions.
In terms of relevance, I think that the decedent's feelings of pressure from the defendant and his state of mind go to the issue of comparative negligence and the defense raised. I think in terms of probative value, although it isn't as probative as showing direct knowledge on behalf of your client, when it comes to the behavior of the decedent and why the decedent took certain actions and whether those were motivated by your client or self-motivated, those are have some probative value that is not substantially outweighed by its prejudicial effect. I'll allow the questioning. We'll bring back in the jury.
Your Honor, prior to doing that, I just wanted to clarify, you asked that I lay some more foundation in terms of the statement that was made or where they were. I just wanted to be clear.
Well, I think that it helps me in ruling if I have a little more context. So for instance, with the prior sidebar, had we had some foundation as to this witness's experience with heroin users, as opposed to it being offered post in an offer of proof, that would have been helpful in terms of ruling on that earlier objection. And again, I think some foundation can be laid showing that this is within earshot of Avery Hitchcock or something along those lines, so that it tips me off before the objection comes that the context is going to guide me in terms of the ruling. Make sense?
Yes, Your Honor.
All right, we'll bring back in the jury.
Okay, Your Honor, the jury has returned.
Thank you, Mr. Capacious. Ms. Goja. Oh, before we do that, and members of the jury, thank you for your patience. Again, I'll try to keep these to a minimum. Ms. Goja.
I'm just going to re-ask the last question. Did you speak to Ernest at all on June 20th, Mr. Matz?
Yeah, I did on set. In between takes. I was still really concerned that he was doing heroin.
And can you tell us what you said to him?
Yeah, I pulled Ernest aside and I said to him, "You don't need to do this to yourself."
And how did Ernest respond?
Ernest looked at Avery Hitchcock and said, "Yes, I do."
Did you see Ernest at all after that day?
No. Ernest died from a heroin overdose the next day.
Thank you. No further questions at this time.
Cross?
Yes, Your Honor. Mr. Matz, you've had a lot of experience working with Mr. Hitchcock.
Yeah, the 2 movies prior to Cobain.
And in your own words, you've loved working with him.
I did, yeah.
You've had the opportunity to observe Mr. Hitchcock working with other actors on his sets.
I have, yes,
Lead actors like Mr. Ayers and Cobain.
that's correct.
And you know that actors who work with Mr. Hitchcock sometimes go on to win Oscar nominations
Yeah,
or get cast in other big movies or major roles.
that's correct.
You're aware that Mr. Hitchcock believes in actors on his sets using what's known as method acting.
Yes,
Method acting being a technique where the actor tries to totally and emotionally identify with the character that they're playing.
yeah, I believe Avery Hitchcock says you need to be that character, live as they live.
Right. So, and now you've been working in this industry for around 20 years.
That's correct.
And you've seen some specific instances of how method acting is used in the industry.
Yeah, I have.
Sometimes an actor can take method acting too far and hurt themselves.
Yeah, method acting can be taken too far.
And sometimes an actor can use restraint when method acting.
Yeah,
In other words, there's a spectrum of how method acting can be used.
I mean, it depends on the actor and the director, but I suppose so, yeah.
And method acting isn't the only technique, like you said, an actor can use.
That's true.
In fact, you yourself aren't a method actor.
Yeah, I don't consider myself one.
Now, you've worked with Mr. Hitchcock for 3 films,
Including Cobain, yes.
and Mr. Hitchcock never demanded that you method act.
No,
In fact, Mr. Hitchcock doesn't require any actor to actually method act on the set of any of his movies.
I mean, he asks for method acting, but the actor decides whether or not to use it.
Right, because as you've said, it's always the actor's choice whether or not to use method acting in an Avery Hitchcock movie.
That's true.
Let's talk about the filming of Cobain. In the movie, you were playing Kurt Cobain's band manager,
Yep, Danny Goldberg.
and the movie was 3 weeks into shooting when Mr. Ayers unfortunately passed away.
That's true.
And you were on set for 7 of those days.
I was.
All of your scenes were with Mr. Ayers,
Yeah,
so you spent a lot of time with him.
that's correct.
And Mr. Ayers was playing the lead in this movie.
Yes, he was.
So that means he was in almost every scene.
That's true.
And you got to observe him on the set.
I did.
You said he looked exhausted and tired on set,
He did.
but you also thought that he was doing a good job.
Yeah, after that June 5th take, he started doing really well.
In your own words, you thought Mr. Ayers was magic in playing his role.
It's true.
And from what you could see, you thought Mr. Ayers wanted to be perfect.
Yeah, that's correct.
You also thought he was a great scene partner.
That's true.
Mr. Matz, you were here and watching when the plaintiff played those 2 video clips.
Yeah, I was here.
Even after that scene, that last one was filmed, you still thought Mr. Ayers was nailing his role.
Yeah, specifically after that scene, he was nailing his role.
In fact, you didn't have any problem shooting any of your scenes with him after that time.
I don't remember, but I don't think so.
However, you also didn't spend any time with him offset.
Just the cast party before shooting began.
That's right. The cast party was the only time you ever saw him offset.
That's correct.
You didn't see how Mr. Ayers prepared for his role offset.
No.
You never saw Mr. Ayers in his home.
No.
You testified on direct that you went to Mr. Hitchcock and told him that you were worried Mr. Ayers might be using heroin.
I did.
And according to you, that conversation occurred sometime between June 12th, 10th and 12th.
It happened on either June 10th or 12th.
Right. And according to you, Mr. Hitchcock told you that he would take care of it.
Yeah,
And then you continued shooting with Mr. Ayers for around another week.
it did.
That was through June 20th.
That's correct.
And during that time, you still observed that he was doing a good job.
Yes,
Between takes, you mentioned on direct, you thought he looked high or strung out.
that's true.
But when the cameras were rolling, he was superb.
Superb and looking high and strung out. Yeah,
To be clear, though, in your own words, when the cameras were rolling, he looked superb.
yeah, that's true.
Mr. Matz, in all the times that you've worked with Mr. Hitchcock, you've never seen him ask an actor to do anything illegal.
No,
You've never seen Mr. Hitchcock ask a performer to use drugs.
no,
And you've never seen Mr. Hitchcock ask Mr. Ayers to use drugs.
I didn't see it personally. No,
And you never saw Mr. Ayers use drugs on the set of Cobain.
no, not personally.
No further questions, Your Honor.
Redirect.
No redirect, Your Honor.
Thank you, Mr. Metz, for your testimony. You can step down. Old habits die hard. I don't know where he would step. All right. Any further witnesses for plaintiff?
Yes, Your Honor. We called Jack Ayers to the stand.
And Mr. Ayers, we will deem sworn. And Ms. Tedesco, your witness.
Yes, Your Honor. Good morning. Can you please introduce yourself to the jury?
My name is Jack Ayers.
How did you know Ernest Ayers?
He was my husband of 3 years. We met when we were undergrads at NYU.
What do you do for a living?
I'm a psychologist. I'm licensed in New York, and I've been treating patients for about a year.
I'd like to talk about Ernest. What did Ernest do for a living?
He was an actor. When we were at NYU, he was in the Tisch School of Arts. It's one of the best acting schools in the world.
What kind of roles did Ernest have over the course of his career?
He had a couple of small off-Broadway plays and one movie. In 2018, he was the lead in an off-Broadway play. And in 2019, he was cast as the lead in the movie Cobain.
Before Cobain, about how much was Ernest making in a year?
He was making about $40,000 a year, and that was between his acting and other odd jobs that he would work.
Did Ernest ever do illegal drugs?
Yes, in 2016, he developed a heroin addiction.
Can you describe for the members of the jury what Ernest was like during this time?
It was terrible. He used almost every day. He couldn't stop. He wasn't sleeping. He was vomiting constantly. He had these horrible mood swings. He missed auditions. He lost weight. He didn't even look like himself. It was really hard, and we almost split up over it.
Did there ever become a point where Ernest was able to stop using heroin?
Yes, after a few weeks, he checked into rehab, and then he came home and was his old self, but he was completely sober. No drugs at all, no alcohol, not even wine with dinner.
Was Ernest able to stay sober after the rehab?
Yes, he was sober for 3 years. We celebrated the anniversary of his sobriety every year.
I'd like to talk now about how Ernest obtained the role in Cobain. How did Ernest get that role?
So Carrie Bricker, a talent agent from Los Angeles, contacted us and invited us to a lunch with the director, Avery Hitchcock.
What was Ernest's reaction to this invitation?
Well, we couldn't believe it. Avery Hitchcock is one of the biggest names in Hollywood.
Did you end up going to lunch with Avery Hitchcock?
Yes, the three of us went to lunch in July of 2018. The restaurant was called the Olympic Flame, and it's one of the fanciest restaurants in Manhattan.
What did Mr. Hitchcock say during that lunch?
Well, Mr. Hitchcock asked Ernest to play the lead in his movie, Cobain.
Did Ernest accept the offer?
Yes, Ernest signed the contract right then and there.
What was Ernest going to make by being cast in the defendant's movie?
The contract was for $500,000.
Jack, in a minute, I'm going to show you a copy of Exhibit 3, which is already in evidence up on the screen. Can you explain what this is?
Yes, this is the contract. This is the contract that Ernest signed.
Who was the contract between?
Oh, it was between Ernest and Hitchcock Studios.
And can you please read for the jury those two highlighted sentences that you see there?
Yes, the first one states, studio agrees not to ask performer to do anything that exposes performer to unreasonable risk of harm. And the second says, studio acknowledges responsibility to provide a safe set and environment during production of film.
Thank you, Jack. We're going to take that down now. I'd like to talk now about what Mr. Hitchcock asked of Ernest to star in his film. At that lunch, did you have any conversations about method acting?
Yes, Hitchcock said that he wanted Ernest to use method acting for his role.
And what was Ernest's response?
Objection, Your Honor. May we have a limiting instruction moving forward?
The objection is overruled as it was previously, but members of the jury, you're going to hear some statements that are made by certain people who are not testifying at this time. And those statements are going to be offered to show Avery Hitchcock or defendant Hitchcock Studios awareness of certain things. You're not to consider them for the truth of the content of those statements. Ms. Tedesco, you can proceed.
Yes, Your Honor. So when Hitchcock asked about method acting, what was Ernest's response?
Well, Ernest mentioned that Kurt Cobain had been addicted to heroin, and Hitchcock replied, I understand.
What was Ernest's reaction to this?
Well, Ernest explained that he himself had been addicted to heroin.
How did Mr. Hitchcock respond?
Hitchcock said, I know. It's one of the reasons I knew you could nail this role.
What did Ernest say to that?
He said that he couldn't use again.
Did Mr. Hitchcock respond to that?
Yes. Mr. Hitchcock paused and said, we will try it your way.
Now, I'd like to talk now about Ernest's behavior when he started filming Cobain.
Objection, argumentative.
Overruled.
Where was Cobain filmed?
It was filmed in Los Angeles, California. Ernest moved into an apartment out there for filming, but I stayed in New York.
And who paid for that apartment?
Hitchcock Studio.
Relevance?
Overruled.
I'm sorry, Jack. I asked who paid for that apartment.
Yes, Hitchcock Studios paid for the apartment and for the moving expenses.
Did you speak to Ernest while he was in LA?
We spoke by the phone almost every day, even if it was just for a minute, just to say, hi, I love you.
What was Ernest's demeanor like during those calls?
He seemed very excited at first. He was very focused, happy, eager.
Did that ever change?
Yes, it changed when the movie began shooting.
I'd like to talk about some of those changes. Did you talk to Ernest on his first day of filming, June 3rd, 2019?
Yes, we did.
What was his demeanor like that day?
I could tell he sounded upset. I could hear it in his voice.
Did you ask him what was wrong?
Of course. He told me that Avery said that his performance was unacceptable.
Your Honor, may I ask for another limiting instructions just for clarity for the jurors?
I don't recall the limiting instruction for this particular part of the testimony, but members of the jury, you're going to hear a statement from Ernest Ayers about who he thinks may have put something in his room. Mr. Ayers at that time did not have any personal knowledge of that, but you can consider it for the effect that that belief had on Mr. Ayers's actions after he saw that. And Ms. Tedesco, you can inquire.
Yes, Your Honor. Did you speak with Ernest on June 5th of 2019?
Yes. When I was on the phone with Ernest that morning when he walked into his trailer on set.
What did he say when he got into his trailer?
He told me there's a syringe on the table in my trailer. I'm looking at a syringe full of, it looks like heroin. Avery must have put heroin in my trailer.
Did he say anything else about that?
Yes, he also said there was a note on a napkin. I asked him if he was going to use the heroin, and he said, I have to go, and hung up the phone.
When's the next time that you spoke to Ernest?
The next time we spoke was on the evening of June 6th, and he told me that he hadn't taken the heroin.
Did you speak to him after that?
Yes, but our calls and FaceTimes, they weren't like before. They were much shorter.
Now, during those calls and FaceTimes, can you describe what Ernest looked and sounded like?
Yeah, on the phone and when we FaceTimed Ernest, he appeared to become upset, frustrated, nervous. He looked really sick. He had these huge mood swings. He would slur his words. He would speak too slowly. He looked sweaty and like gaunt.
Had you ever seen this type of behavior before?
He looked and sounded the same as when he was using in 2016.
Did you ever confront Ernest about your suspicions that he was using?
Yes, I brought it up to him probably 3 times.
And what did he say when you brought it up to him?
At first, he said he was just getting more into character, but on June 19th, he admitted to me that he was doing heroin again. He was sobbing. He was so upset. He said that Avery Hitchcock was making him.
Now, did Ernest say after he admitted he was doing heroin that he continued to, that he planned on continue using it?
Your Honor,
Well-
may I have a final limiting instruction on that last statement?
Yes, so members of the jury, as to Mr. Ernest Eyer's statement that Avery was making him, again, Mr. Eyers made certain statements. You can consider them for what was going on in Mr. Eyers' mind. And when I say Mr. Eyers, I mean Mr. Ernest Eyers, as to why he took certain actions or didn't take certain actions. But you shouldn't take them for the truth of the statement that Avery Hitchcock was actually making him. That's something you'll have to determine from other evidence in this case. Ms. Tedesco.
Yes, Your Honor. Now, Jack, after Ernest admitted that he was doing heroin, did he tell you if he planned on continue using heroin?
Well, he said, I want to stop, but I can't. I'm addicted again. And even if I could, I'm afraid Avery will fire me if I come in sober.
Now, I know this might be difficult, but I'd like to turn now to the point after Ernest told you he was using heroin. Did you ever travel to LA in June of 2019?
Yes. After he admitted to me that he was using heroin on June 19th, I booked a flight and went to LA that Friday. It was June 21st, 2019.
What happened when you got to LA?
Well, I went to Ernest's apartment and I found him on the couch. He was unconscious. He wasn't breathing. He had no pulse. He was covered in his own vomit. I called 911, but I knew that it was too late.
I'm very sorry for your loss. Jack, you testified earlier about a note on a napkin that Ernest had found. Did you ever find that note for yourself?
Yes, I found it in Ernest's apartment on June 21st.
I'm showing you a copy of Exhibit 8, which is already in evidence in just a second. Jack, what is this?
That's the note I found in Ernest's apartment on June 21st.
Now, can you read for the jury what this note says?
Yes, it says, to find Kurt, you have to let Ernest go. Call 555-651-1892. He will help you find him.
Thank you, Jack. We can take that down now. Now, Jack, do you know if Ernest ever ended up calling that 555 number?
Yes, he did. Our cell phones were on a family plan. So I printed out a log of Ernest's phone calls from June of 2019.
Jack, now I'm showing you a copy of Exhibit 6, which is already in evidence. What is this?
That's the phone logs that I printed out.
And can you tell the jury the number of times that your husband called that 555 number found on the note?
Yes, he called that number 5 times in June of 2019.
We can take that down now. Thank you. No further questions. Thank you, Jack.
Thank you, Ms. Tedesco. Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Mr. Ayers, when your husband got out of acting school, he struggled to get his career started.
Yes,
He graduated in 2014,
that's correct.
and by the start of 2016, you started noticing changes in him that told you something was wrong.
By the start of, I'm not sure what you mean.
In 2016, you confronted Mr. Ayers.
I'm not sure what you mean.
Perhaps I wasn't clear. In 2016 on direct, you mentioned that your husband had started using heroin,
Yes,
and you confronted him at that time.
yes, I did.
You two almost split up over it.
Yes,
And he told you then that he was using heroin.
yes,
He was injecting it with a syringe.
I believe that that's correct.
In your words, that's how he used in the past.
Yes,
He was using heroin almost every day.
yes,
He told you that he was using because of stress.
I believe that's what he told me. Yes,
During his intervention, he told you he was stressed about his career.
I believe that's what he told me during his intervention. Yes,
And he couldn't stop.
he was addicted.
You watched him become emotionally and physically sick.
Yes,
And I'm sorry, but he started missing auditions.
yes, he did.
He was having terrible mood swings.
Yes,
You saw all those changes in 2016 because you were with him at the time.
yes,
And after 4 weeks of Mr. Ayers struggling with these symptoms, you finally got him to go to rehab.
yes. We staged an intervention and he went to rehab and came back sober.
Thank goodness he did, because he got sober.
Yes,
Now, let's talk about when Mr. Ayers was hired for Cobain. On direct, you mentioned the lunch between yourself, Mr. Ayers, and Mr. Hitchcock.
yes,
That lunch took place in July of 2018.
yes,
And during that lunch, Mr. Hitchcock asked Mr. Ayers to use method acting for the role of Kurt Cobain.
yes,
You knew who Kurt Cobain was.
yes. I know who Kurt Cobain was.
You know Kurt Cobain was a heroin addict.
Yes,
And so you assumed that Mr. Hitchcock was asking your husband to use heroin for the role.
well, Ernest explained I'm a recovering addict, and Hitchcock replied and said, I know it's one of the reasons that I knew you could nail this role.
Mr. Ayers, my question was much simpler. It is simply whether or not you assumed, based on what you heard, that that's what Mr. Hitchcock was asking.
Yes, based on that conversation.
But isn't it true that at no point during that conversation did Mr. Hitchcock actually ask Mr. Ayers to use heroin?
Not explicitly, but Mr. Hitchcock said that Cobain was a heroin addict and that he knew that it was one of the reasons that Ernest could nail the role.
So that's a yes to my question, Mr. Ayers.
Not explicitly.
Now let's move towards the shooting of Cobain. As we know, your husband's sobriety ended in 2019 while shooting the movie.
Yes,
You claim you saw his sobriety end?
I'm not sure what you mean by that.
Well, you started noticing changes in him when he started filming.
That's correct.
Cobain was filmed in Los Angeles, correct?
That's correct.
And you didn't actually move to Los Angeles, excuse me, with Mr. Ayers for the filming, did you?
No, I didn't. I stayed in New York.
And so the changes that you say you noticed were through hearing him on phone calls?
And seeing him on FaceTime.
That's right. You had a handful of FaceTime calls with Mr. Ayers during that time.
Yes.
Each one of those calls lasted a few minutes.
Give or take, yeah.
And of those 3 to 4 FaceTime calls that lasted a few minutes, those were the only times you actually saw Mr. Ayers while he was filming.
That's correct.
You didn't have a chance to actually watch Mr. Ayers while he was filming on set.
No, I never watched him film on set.
You didn't see him while he was playing a character.
Like I said, I never saw him like filming on set.
You also didn't see him during breaks.
I'm not sure the exact times that we FaceTimed.
But you'd agree you didn't get much of an opportunity to actually see what he was like at home.
Well, we FaceTimed 3 or 4 times.
Okay, Mr. Ayers. But your husband did tell you about some of the things that happened on set.
Yes, that Avery Hitchcock put heroin in his trailer.
Objection, Your Honor, non-responsive. Motion to strike the witness's answer.
Everything after yes will be stricken, the objection sustained. And members of the jury, if I strike testimony, that means that you should pretend it never happened and disregard it entirely. Ms. Rhodey.
Now, Mr. Ayers, I'll ask you again. Your husband, Mr. Ernest Ayers, did tell you about some things that happened on set, correct?
Yes,
For instance, he told you about what happened during the first day of filming on June 3rd.
yes,
That was the first time he actually had to perform as Kurt Cobain?
perform on set, yeah.
And his first day had not gone well.
No,
In your words, Mr. Ayers was devastated
yes,
because Mr. Hitchcock had criticized his performance,
yes,
and you knew it must have been stressful for Mr. Ayers to have his performance criticized by Mr. Hitchcock.
yes,
Eventually, you started to see further changes in your husband,
yes, I did.
changes you thought you recognized because you'd seen them before.
Yes, I had.
In your words, he became emotionally and physically sick,
That's correct.
started having mood swings,
That's correct.
slurring words,
Yes,
looking sweaty.
yes,
And as you mentioned, your fears of your husband relapsing were confirmed when you spoke to Mr. Ayers on June 19th.
yes, on June 19th.
That's when he finally told you that he started using heroin again.
Yes,
And according to you on that June 19th call, Mr. Ayers told you he was using heroin for a while.
I believe that that's correct.
He claimed he started on June 5th,
Yes,
about 2 weeks before his death.
yes,
The same day that you were on the phone with him and he said he walked into his trailer and found a note and a syringe.
yes,
But to be clear, you didn't see that syringe yourself, did you?
no,
Your Honor, I have here a copy of the June 22nd report of autopsy for Mr. Ayers. This has been pre-admitted as Exhibit 12 under the court's October 1st pretrial order. It can be found on page 22nd of the record,
Thank you.
publishing for the jury. Mr. Ayers, I apologize, but I must ask you these questions. You've reviewed the report for your husband's autopsy.
yes,
You're aware of what it says.
yes,
The report states that the oldest wounds on your husband's body were at most 5 days of age,
it says potentially up to 5 days of age. Yes,
potentially up to 5 days, so maybe even less.
yes, the wounds that were found are potentially up to 5 days.
No further questions, Your Honor.
Redirect.
No, Your Honor, this witness may step down.
And Mr. Ayers, thank you so much. I'm sorry for your loss. You can step down.
Thank you, Your Honor.
Any further witnesses for the plaintiff?
No, Your Honor, the plaintiff rests.
And I believe all evidence referred to was previously admitted, so we don't have any exhibits to move into evidence at this time. Normally, I would take a 5-minute recess. Anything we need to do before we take a break for 5?
Yes, Your Honor. Oh, excuse me.
Go ahead,
at
Mr. Enriquez.
Thank you. At this time, the defense would like to make a motion outside of the presence of the jury.
All right, members of the jury, will excuse you at this time. We'll have you come back in, let's see, it's 10:45. I don't think this motion will take very long, but we'll give the jurors 10 minutes and resume at 10:55. Maybe a little bit earlier if we can shorten time. We'll excuse the jury at this time and take up the motion.
So if all of our jurors could please use their breakout room feature to start moving themselves to the room called jury. This is our customary break, so you're not missing much. You can head to the jury room and come back, we'll say at 10:54, or I should say 54 after the hour, since I know that you're in different parts of the country, and I'll start moving you if you haven't already moved.
Okay, Your Honor, jury is out of the room.
And Mr. Enriquez, you're making the motion on behalf of the defense?
Yes, Your Honor.
Go ahead.
Pursuant to Federal Rule of Civil Procedure 50, we move for a judgment as a matter of law. Viewing the evidence in light most favorable to the non-moving party, the plaintiff has failed to present enough evidence sufficient for a reasonable juror to find that it is more likely than not that Hitchcock Studios caused Mr. Ayers' death. They have to prove 2 things for causation: that Mr. Ayers' overdose would not have occurred but for the defendant, and second, that the overdose was reasonably foreseeable result of that negligence. And the plaintiff has failed to meet this burden as to both elements of causation, because one, their case is built around Mr. Jack Ayers' speculative and non-firsthand recollection of events, which are directly refuted by the timeline of heroin as set forth by the autopsy report, which was just published. And second, the plaintiff has not established that a reasonable person, after only 15 days of shooting, could foresee Mr. Ayers was using heroin when he was playing a heroin addict on a set that encouraged method acting, and where Mr. Ayers was found to have used heroin in the privacy of his own home. As a result, the Hitchcock Studios, we believe, is entitled to a judgment as a matter of law.
All right, thank you, Mr. Enriquez. I don't need to hear from plaintiff. I believe that the evidence is sufficient for a reasonable juror to conclude by preponderance of the evidence that the defendant's actions approximately caused damage to the plaintiff and failed to meet the standard of care. Defense has preserved its record, and we'll take a break until 5 minutes before the hour.
Yes, Your Honor.
Your Honor, we'll start bringing the jury back just before that, so that way you can begin when it's 5 minutes till.
Sounds great.
Your Honor, the jury is, there's just one juror that we're moving back.
Mr.
But
Capacious, give me
otherwise-
just a moment. Unfortunately, my headset disconnected during the break and I didn't hear what you were saying.
Are you good to go now?
Yes.
There's just, I believe, one juror that we need to move back, and then we'll be ready to proceed.
Let me know when and we'll get started.
Your Honor, may we request a time check from the bailiff, please?
Absolutely.
Plaintiff has used 29 minutes, 51 seconds. So that means 30 minutes and 9 seconds remain. Defense has used 23 minutes and 15 seconds. So that means 36 minutes and 45 seconds remain. And the jury is now all back. I'll turn it over to Your Honor.
Thank you so much, Mr. Capacious. We're back on the record. All counsel are present. Our jurors are present. Plaintiff has rested, and we're now going to hear from the defense members of the jury. And who is the defense's first witness?
Your Honor, the defense calls Ms. Delaney Gold Diamond.
And Ms. Gold Diamond has been sworn. And Ms. Rhodey, whenever you're ready, you can inquire.
Yes, Your Honor. Good morning.
Good morning.
Please introduce yourself and tell us what you do for a living.
My name is Delaney Gold Diamond. I'm a talent agent based in New York, and I run my own agency.
What does a talent agent do?
I help performers find work through my relationships in the industry. I pitch clients to directors, help land them auditions, and manage their careers.
How did you know Mr. Ayers?
I took Ernest on as a client in 2014, right when he graduated from Tisch School of the Arts.
How would you describe your relationship with Mr. Ayers?
I loved working with Ernest. He was a good guy and a good actor, and we stood by each other through some really difficult times. And I was just so proud of him when he got that role in Cobain.
Now, you said he went through some tough times. What do you mean by that?
Well, in 2016, he was addicted to heroin.
How did you find out about his addiction?
Towards the beginning of that year, he started missing auditions, and I knew something had to be wrong. So I called him, but he wouldn't answer my calls. So I called his husband, Jack, and he's the one who told me.
When Jack told you, what did you do?
I helped organize an intervention for him with Jack. We got his parents and friends to come sit down with him. We all told him how much we loved him and that we were really concerned.
How did the intervention go?
It was really emotional. Ernest was so overwhelmed, he started sobbing. He told us, or he said how ashamed he felt, but that he was really thankful for all of us being there.
During the intervention, did Mr. Ayers say why he started using heroin?
He said that he was just so stressed that he started using, and then he didn't know how to stop himself.
While Mr. Ayers was on heroin in 2016, what behaviors did you observe?
Well, I noticed his behavior change, like when he stopped going to auditions and missing my calls. He had never done that before. And then, of course, I saw what he was like during his intervention.
What did you see the night of his intervention?
He looked awful. His skin was dry and red. He, looked like he was in a trance. His eyes were empty. It was really scary.
How did you talk to him in that state?
We couldn't. We all had to sit there for a few hours and wait for him to come down so he could really absorb what we were saying.
So what happened after the intervention?
I helped find him a rehab facility, and he checked in the next day. He stayed there for 2 months.
Now let's move forward to Mr. Ayers' involvement in Cobain. Were you involved in getting Mr. Ayers that role?
No, I wasn't. That was another talent agent.
How did that make you feel?
To be honest, I was a little upset at first. It meant I didn't get the commission, and that is how I make my living. But I was okay with it.
How was your relationship after that?
It was fine. You know, he had this amazing opportunity. I was so proud of him, and that casting helped me line up other possible roles for him. And then it also helped me develop a relationship with Avery Hitchcock.
What do you mean?
Well, now that I know Avery Hitchcock, I've been able to pitch other actors for his productions. And I've actually been able to get a few actors work that way. And I've also expanded my agency since then.
Now let's move to the time period where Mr. Ayers was actually shooting Cobain.
Mhm.
Were you in contact with Mr. Ayers during that time?
I visited him actually on the set in LA on June 18th.
How much time did you spend with Mr. Ayers on June 18th?
About 3 hours total. I spent some time on set, and then we caught up over dinner for about 2 hours. I think dinner ended around 8 p.m. So
You mentioned that you went to set. How did Mr. Ayers react to seeing you on set?
he seemed so happy to see a familiar face. He gave me a big hug and a kiss on the cheek when I got there.
And how long did you get to observe filming?
For about an hour.
How did Mr. Ayers look when the cameras were rolling?
Well, when the cameras were rolling, he looked really strung out. He was doing a scene where Kurt Cobain was already into his drug addiction.
Well, what about when Mr. Hitchcock called cut?
He looked fine.
And finally, how was Mr. Ayers' demeanor during dinner?
He looked tired and he seemed a little distracted, but he had just gotten done filming for 10 hours, so I chalked it up to that.
At any point during that day, did you suspect that Mr. Ayers was using drugs?
No, not at all.
Why is that?
I had seen him in 2016 when he was using heroin, and the Ernest that I saw in June 2019, the Ernest who had just spent 10 hours on set filming and then went out to dinner with me for another 2 hours, that wasn't the same Ernest that I saw in 2016 when he was at his lowest.
No further questions, Your Honor.
Ross?
Yes, Your Honor. May I proceed?
Yes.
Good afternoon, Ms. Gold Diamond. You were asked on direct whether you got Ernest the role in Cobain, right?
That's right.
The talent agent that actually got him that role was Carrie Bricker.
Another agent got him that role. That's right.
And that agent was named Carrie Bricker, right?
I believe so. I'm not exactly sure.
You spoke with Carrie Bricker on July 1st, 2018, right?
I did speak with Carrie Bricker.
And she had said she had a client looking for something very specific.
She did say that.
And you now know that that client was Avery Hitchcock.
Objection, speculation.
Sustained, subject to further foundation.
Ms. Gold Diamond, she asked you about your client, Ernest Ayers.
That's right.
And she only asked you 3 questions about Ernest, right?
That's right.
First, she asked if Ernest could act.
Yes.
Then she asked if he could sing.
Yes.
And the only other question she asked was if Ernest had a history of drug use.
She did ask that.
And you told her that Ernest suffered from a heroin addiction.
I did.
And that he was sober for a few years.
That's right.
And you didn't say, don't tell your client that Ernest had a substance abuse problem, right?
Action relevance.
Overruled.
Ms. Gold Diamond, I'll ask again. You didn't say, don't tell your client that Ernest suffered from a substance abuse problem, right?
No.
Now, I'd like to talk to you about your relationship with the defendant, Hitchcock Studios. Avery Hitchcock and Hitchcock Studios reached out to you in November 2020.
That's right.
That's after Ernest died.
Yes.
They wanted to start casting your clients in their films.
Did.
They had never reached out to you like that before.
No,
And now you receive commissions from your clients who obtain roles in Hitchcock films.
that's right. That's, how an agent gets paid. It's through commission.
Right, that's how an agent gets paid. And to date, you've made over $100,000 in commission from their work for Hitchcock Studios, right?
That's right.
You're making 4 times what you were making beforehand.
That's right.
Because of Avery Hitchcock, you've been able to expand to film and open an LA office.
That's true.
And today you're testifying as a witness for the defendant.
I am.
Now, I'd like to talk about that testimony a little bit. You claim that when you saw Ernest Ayers on set, he didn't look like he was on drugs.
He didn't.
But you only saw him for 3 hours in June of 2019, right?
That's how long I saw him.
Let's talk about what you. I'm sorry. Oh, I'm sorry. There must have been feedback. I'd like to talk about what you did see. You only watched 1 hour of filming, right?
That's right.
And you admit that during that filming, Ernest looked like he was strung out.
He did.
But you claim once Avery called cut, he looked totally normal.
He looked fine.
You were only with him for 2 hours after that filming.
That's right.
You went to dinner,
Yes,
and Ernest looked tired and distracted.
he did.
His eyes were heavy.
They seemed empty. Yes,
And those 3 hours in that one day was the only time you spoke to Ernest while he was filming Cobain.
yes.
You didn't call him.
No, I knew he was busy.
You didn't text him.
No,
You never checked in on him.
I visited him.
You have no idea what he was doing other than that one time you visited him on the set of Cobain, right?
I knew he was acting on the set of Cobain, but now I didn't see him every day.
No further questions.
Redirect.
Yes, Your Honor. Ms. Gold Diamond, how is your relationship with Mr. Hitchcock affecting your testimony here today?
It's not. Look, I really cared about Ernest. You don't spend that much time with somebody and not care. I just came here to tell the truth.
No further questions, Your Honor.
Any impeachment on redirect? I'm sorry, on recross?
No, Your Honor.
May this witness step down?
Sorry, excuse me, Your Honor. Yes, this witness may be excused if Your Honor allows it.
Thanks, Ms. Gold Diamond. Thank you so much. You're excused at this time. Any further witnesses for the defense?
Yes, Your Honor. The defense calls Mr. Avery Hitchcock.
And Mr. Hitchcock has been previously sworn. Mr. Enriquez, your witness, sir.
Good. It is still morning. Good morning, Mr. Hitchcock. Please tell us what you do for a living.
Hello, I am a filmmaker and CEO of Hitchcock Studios.
How did you become a filmmaker?
Well, I went to Boston College to study film, but I actually dropped out after my sophomore year. I wanted to do the real work instead of just studying it. So I moved to LA.
What happened after you moved to Los Angeles?
Well, I got lucky. I scored an entry-level job at MGM Studios and started learning the business there. And in my free time, I started writing scripts on the side.
We've heard today that you've been successful in your career, but what was your first big break?
Well, after a few years, one of the scripts that I wrote got picked up for a movie, and that movie won at Sundance Film Festival.
What kind of work did you do after Sundance?
Well, after that, I started getting offers for directing and producing films pretty regularly, and well, I guess I've been doing it pretty much ever since.
Has your work won any other industry awards?
Yes, the films I've directed have won, I think, 40 Academy Awards. One actually won for Best Picture, and I won one for Best Director.
What about your actors? Have they won any awards for working with you?
Yes, 12 of the actors who I've worked with have gotten nominated for an Oscar for their work in my movies.
Now let's shift to talking about your directing style. We've heard it said today that you prefer working with unknown actors. Can you tell us why that is?
Yeah, so lesser known actors help the audience stay immersed in the world of the film. The audience is seeing the character, not the actor or some other role the actor played.
We've also heard a lot today about the term method acting. Could you tell us your definition of method acting?
Yes, so method acting is an old acting technique where the actor tries to thoroughly identify with the inner motivations and emotions of the character they're playing.
Do you have a preferred acting style for your actors to use in your films?
Yes, I would like them to use the method.
Why is that?
I think it creates a more believable experience for the audience. The idea is that an actor shouldn't portray anything they haven't already inwardly experienced.
Can an actor take method acting too seriously?
Oh, yes. Actors can really go too far with it and hurt themselves. I know that there are actors who have gotten sick from exposure and actors who have sustained serious psychological trauma from method acting. It doesn't happen on my set, but it's certainly something that's known in the industry.
So, if you know that an actor can take method acting too seriously, how do you keep it from happening on your own sets?
I work with my actors to create a balance. I want to push them for their best performance, of course, but safety has always come first for me.
I'd like to shift now to talking about Mr. Ernest Ayers. How did you come to cast him in your movie?
Well, I saw Ernest in a play that he was doing at the time, and I was just blown away. Ernest was a brilliant actor, a fantastic singer, and it certainly helped that he looked a lot like Kurt Cobain. He really had that tortured artist look that the role called for.
We've heard a lot today about Mr. Ayers' heroin addiction. Did you know Mr. Ayers had a previous heroin addiction before you cast him in the film?
No, I did not.
If you had known about his prior addiction, would you still have cast him?
Well, sure. In retrospect, it may have helped explain why he was so good in his role. I mean, he already had that inward experience with the drug.
So once you started filming, how was Mr. Ayers' acting?
At first, it wasn't great. That first day, Ernest's performance, it was pretty flat. It really was not what I was expecting. We ended up doing 62 takes of that scene.
Why 62?
Well, it's the first scene in the movie. It's the very first thing the audience sees, so it's really important. And I just wanted to give Ernest the chance to nail it on his first day on set.
Did he nail it?
No, he was really struggling with it. So I called for break and said that we would just shoot next week.
You said that you could tell that Mr. Ayers was struggling. Did you ever find out what was going on?
Yes, on that break, I went to talk to him in his trailer. He had told me that he was anxious because he didn't want to disappoint me. He told me that he had been stressing about this role for all of last year because he wanted it to be perfect, and he was really concerned that that stress was affecting his performance.
Was that the entirety of the conversation?
No. There was a point where he kind of laughed and said, well, maybe some good weed would help with the stress.
How did you respond to that?
Well, I gave him a note with a number to someone I know who sells marijuana. I figured, maybe helping him relax a bit would help with the role.
Whose number was that?
His name is Barry. I like him because he is discreet but professional.
You said you gave him a note with a number. Did you write anything else on that note?
Yes, I wrote on that note, to find Kurt, you have to let Ernest go. given what he was telling me, it sounded like helping him relax would help him find the character a little bit.
So after that first day of filming, how was Mr. Ayers' performance?
It got a lot better.
How do you mean?
He was really getting into his role, acting like Kurt Cobain a lot. You know, he was scratching himself. He was clutching his stomach. He was looking pretty strung out.
Was he like that at all times on set?
Oh, no, not at all. He would be like that about half the time, and then the other half he would be normal.
Mr. Hitchcock, did you ever suspect that anything was wrong?
No, I thought that he was doing the work. You know, Ernest, he graduated from one of the best acting schools in the world. And, you know, if he really was struggling, I would have assumed he would have come to me.
Would you normally check in with an actor who is using method acting on one of your sets?
No. When an artist is performing at the level that Ernest was performing at, you do not interrupt them with questions. It takes them out of the character that they're playing.
Mr. Hitchcock, have you ever worked with an actor named Chandler Matz?
Yes. Chandler has been in 3 of my movies. I love working with the guy.
Did Mr. Matz come to you about Mr. Ayers' behavior with concerns?
No, he did not.
Did anyone else ever tell you that they thought Mr. Ayers was using heroin?
No, not that I recall.
If Mr. Matz, or anyone else for that matter, had come to you with such a concern, what would you have done?
I would have gone to Ernest and made sure he was okay, of course. Like I said earlier, safety always comes first for me on my sets.
I need to now ask you some questions about Mr. Ayers' behavior during the last days of filming on Cobain. Mr. Hitchcock, are you familiar with Mr. Ayers' coroner's report?
Yes, I have read that.
Your Honor, I have Exhibit 12, the coroner's report for Mr. Ayers. Pursuant to the October 1st order, it's been pre-admitted and authenticated into evidence. May I publish it?
Yes, and as I've said, all the admitted exhibits can be published without further leave from the court.
Yes, Your Honor. Mr. Hitchcock, can you please take a look at the paragraph labeled external examination?
Okay, I'm there.
Directing your attention to the sentence, second to last sentence, which reads, body shows 9 wounds, 6 in the upper left thigh and 3 in the left medial humerus, consistent with intravenous injections at various stages of healing. Mr. Hitchcock, at any point on set, did you see any wounds on Mr. Ayers' upper thigh or arm?
No, I never did.
Directing your attention to the following sentence, which reads, wounds range from appearing fresh to potentially up to 5 days of age. Mr. Hitchcock, what kinds of scenes were you shooting during those last 5 days?
Those last 5 days, we were shooting scenes from Kurt Cobain's life where he was pretty deep into his addiction.
Thank you, Ms. Rhodey. You may take down the exhibit. So what was Mr. Ayers' job playing Kurt Cobain requiring of him during those last 5 days?
Well, he was playing someone who was on heroin, so he would have to look and act like someone who was addicted to heroin.
Did it ever cross your mind that Mr. Ayers was using heroin to help him shoot those scenes?
No, not at all.
Did it ever cross your mind that Mr. Ayers might be using heroin at any point during filming?
No. I mean, he was an excellent actor, but I never thought that he was using.
No further questions, Your Honor.
Cross?
Your Honor, I'm sorry to do this, but prior to cross, we request a sidebar.
All right, so members of the jury, I'm hoping that this will be the last time we do this. We'll have a short sidebar.
Hey, jurors, please move yourself to the room marked jury. I see you're already doing that, and we'll help everybody else get there.
Okay, Your Honor, jury is out of the room.
Ms. Goja.
Again, I am sorry to do this, but Your Honor, we met and conferred with opposing counsel pre-trial, and we met and conferred in front of you, and we agreed to specifically not mention any instances of dangerous activities related to method acting that happened on Mr. Hitchcock's set. Now, instead of excluding all of that testimony, Mr. Enriquez asked Mr. Hitchcock whether there were any issues regarding to method acting on his set. And he said, quote, it doesn't happen on his set. And he said, quote, safety always comes first. At this point, Your Honor, we believe this is a violation of motion in limine. However, Your Honor, we are not allowed rebuttal witnesses in this jurisdiction, so we cannot recall Mr. Matz to the stand. So we request that we're able to read portions of Mr. Matz's deposition that directly contradicts Mr. Hitchcock's testimony. And we ask that it does not count against our time, because we did not ask those questions of Mr. Matz with our understanding that we would not be into that or getting into any of that in today's trial.
May I respond, Your Honor?
Yes.
During our meet and confer, as well as during motions in limine, the motion was specifically to exclude prior instances of method acting on Mr. Hitchcock's sets from before, and also generally in the industry. The opposing counsel wanted to keep the language of that kind of vague, but in the direct examination that we just went through, Mr. Hitchcock didn't speak about any prior instances of method acting on his sets, nor did I ask him any questions along those lines.
What is the proposed portion of the deposition of Mr. Matz that you would seek to admit, Ms. Goja?
Your Honor, it's page 43 of the record, lines 25. And then it is lines 1 through 20, I believe, of page 44.
Give me just a moment. All right, Mr. Enriquez.
Yes, Your Honor. I mean, like I had meant, I'm not sure, Your Honor, if you had made a decision as to my last response, but I can, would you like me to comment as to the?
Well, I think that the issue is this: your client said on my sets, it's safety first. And what Ms. Goja is asking to get into, some of it I don't think is directly relevant to that testimony. But there does seem to be some indication in the deposition of Mr. Matz that shows that Mr. Hitchcock could be impeached on his assertion that safety is first on his sets.
The safety on his sets applies generally to every set and relates to the contract which was brought in. The motion in limine was specifically geared towards past specific examples. Mr. Hitchcock's mention of safety generally being applicable to all of his sets as a director does not invoke the opposing counsel's ability to be able to bring in testimony or a further examination of a prior witness based on language that doesn't have anything really to do with the motion in limine that we had set out in the narrow context that it was laid.
All right. As far as the motion in limine, the notes that I have are that the parties, that counsel agreed that any prior reference to method acting would be excluded under 404B.
Yes, Your Honor.
If I may, Your Honor.
No. But I don't think that the defense can use that and then give the client carte blanche to say, I run a safe set and safety is first when it appears there's contrary evidence, and then say, well, no, we were very specific and said that we were limiting it to prior instances of method acting. I don't believe that that opens the door to the scope of the information that plaintiff seeks to admit. And just because I'm unfamiliar with the deposition testimony of this witness, Ms. Goja, was this witness asked about these instances?
No, Your Honor, this witness was not, so we can't ask him about these things.
All right. What I'm going to allow you to do is on cross-examination, you can inquire, but only about the incident, I believe, with the stunt person that would tend to indicate that the defendant allows physical danger of some kind on the set. And I will allow you to read those portions of the record, I'm sorry, of the deposition transcript during your cross-examination. I'm not going to stop the clock for that, because whether there was a stipulation or wasn't a stipulation, if you wanted to get in this evidence, it would have been on your clock time anyway. But instead of allowing you to reopen or doing something like that, you can ask on cross-examination, and we will consider that deposition testimony as admissible for its truth at the time that you're reading it on cross.
Yes, Your
So,
Honor.
let me just take a look at the different pages because there was a huge section that you wanted to read. The section that I will allow you to read is on page 44, starting at line 7 and going to line 20. I saw them firsthand. You cannot read the part about Avery's reputation. And since we're only looking at one example, just limit the reading of line 19 to how do you know about this? And you may modify, I saw it firsthand, so that the jury is aware that it's based on personal knowledge. All right, we'll bring in the jury.
Yes,
Your
Your Honor.
Honor, just to clarify, these are two separate instances within the lines that you designated me to read.
Oh, then we'll just leave it as is then.
Okay.
The two method, if I was reading it fairly quickly, but if the question and answer starting at line 7 is two different instances of danger, then you can read question on line 17. I'm sorry, question on line 19 and the answer on line 20 up to the point I saw them firsthand. As terms of Avery's reputation, that's excluded.
Yes, Your Honor.
Your Honor, may I
All
bring
right.
back the jury?
Yes, please.
Thank you.
Okay, Your Honor, looks like we have the jury back.
Thank you. And members of the jury, thank you so much for your patience. There was some confusion over a ruling that I made earlier in the trial. Please don't hold that against the attorneys. That was my mistake for not being a little more specific in what I had said before we got you here. So with that, we'll turn it over to Ms. Goja. Ms. Goja, you can inquire.
Mr. Hitchcock, when you first started shooting Cobain, you weren't happy with Ernest's performance, right?
Yes, that's correct.
That first scene should have taken you about 10 to 20 takes maximum,
Yes,
but you directed him to shoot it 62 times.
we did ended up shooting it 62 times. Yes.
Now, after that conversation, I'm showing you Exhibit 8. You claim you didn't leave this note with a syringe of heroin in Ernest's trailer.
I'm not, sorry, can you repeat the question?
Mr. Hitchcock, you claim you did not leave this note with a syringe of heroin in Ernest's trailer.
No, of course not. I gave that note to him on June 3rd.
But you wrote this note, right?
Yes, I did.
We can take that down. After this conversation, you also gave him an article to inspire him and remind him about who he was playing, right?
Yes, I did.
Honor.
Was there an objection, Mr. Enriquez?
Yes, Your Honor. Counsel testifying.
Overruled.
Mr. Hitchcock, after this conversation, you gave him an article to remind and inspire him of who he was playing, right?
Yes, I did.
And that article was titled Talk Screen, Cobain High on Heroin at Time of Death, correct?
If I'm remembering correctly, yes.
Now, on that note we talked about, that's for somebody, that number is for someone named Barry.
Yes, Barry, the man who sells me marijuana.
You claim he only sells marijuana, right?
That's all I've ever bought from him, so yes.
And marijuana has been legal in the state of California since 2016, correct?
I wouldn't know when it got legalized, but it is legal in the state of California.
Okay, so let's talk about who Barry is. You would describe Barry as discreet.
Yes.
Barry operates on a burner phone.
I'm not sure I know what that is. I'm sorry.
Okay, Mr. Hitchcock, you've known Barry since 2016.
Yes, that's true.
You don't know his last name though, right?
No, I do not.
You don't have an address for him.
There might be one in my address book, but I don't have it in front of me.
You never provided your attorneys with that address, right?
I honestly don't recall what I provided in the course of this case. I'm sorry.
But you've been testifying for the past few minutes about what you provided in this case, correct?
Yes, that's true.
Okay, and Your Honor, permission to read stipulation 17 onto the record, that's on page 9.
Yes,
And we also ask for an instruction to the jury as to what a stipulation is.
of course. And so members of the jury, you're going to hear about a few things that we call stipulations. A stipulation is just an agreement between the parties that something is true. And when you learn that something is a stipulation, then you have to accept that fact as true without any further evidence. It's because everybody agrees that it's the truth. Ms. Gojo.
Objection, Your Honor. I'm so sorry to cut in, but may we request that you read the stipulation so as to avoid any mischaracterization?
If there's a mischaracterization, you can make an objection at that time. Ms. Gojo, you can read the stipulation.
Yes, Your Honor. The parties agree that the cell phone associated with the number 555-651-1892 was a prepaid wireless phone, also known as a burner phone. Efforts by the parties and the Los Angeles Police Department to find or identify the owner of this phone were unsuccessful. The phone has not been used since Ernest Ayer's death was publicly reported on June 21st, 2019. Now, Mr. Hitchcock, I'm showing you Exhibit 14. Now, your text, that's the one in green, right?
That's correct.
That text says, I gave one of my actors your number, take care of him. I will cover the $sign, right?
Yes.
And after you set Ernest up with Barry, he started acting more like you wanted him to.
Yeah, shortly after that.
And that text was sent on June 5th, right?
Correct.
Now, you really like to work with we can take that down, thank you. You really like to work with inexperienced actors, right, Mr. Hitchcock?
I do, yes.
In your own words, inexperienced actors are easier to control.
Yes.
Now, I'm showing you a screenshot from Exhibit 10. That's what Ernest looked like on June 5th, right?
Yes, that is him playing Kurt Cobain.
You admit he looks like someone high on heroin?
Yes, because he is playing someone who is high on heroin. Yes,
But Mr. Hitchcock, he isn't wearing any makeup in that photo, right?
I believe that is correct.
Let's take that down. Let's talk about what Ernest was like on set after June 5th. You're very familiar with the symptoms of heroin use, right?
I wouldn't say very, but I am vaguely familiar with it. Yes.
Not just vaguely familiar, Mr. Hitchcock, you are familiar, right?
Yes, I am familiar with it.
And after June 5th, in your own words, there were times where you recognized Ernest's behavior as that of a person addicted to heroin, both on and off camera.
Yes, he was very much into his role.
So that's a yes to my question. There were times after June 5th where you recognized Ernest's behavior as that of a person addicted to heroin, both on and off camera, right?
Yes, that is correct.
And you noticed like he looked like this about half the time, like you said earlier.
Yes.
His face looked flushed.
Yes,
He would scratch at his arms.
he would.
He would scratch at his chest.
Yes, he would.
He would clutch his stomach as though he were in pain.
Yes, he would.
He would stare off into space.
He would.
He was losing weight.
Yes, he did lose a little weight.
And he would disappear for 30 minutes at a time during shooting once or twice a day.
That is correct.
But you didn't do anything about it.
No, I assumed he was method acting.
Well, you weren't concerned at all, Mr. Hitchcock, because in your own words, when Ernest is performing at that level, you don't question things like that.
No, of course not. I didn't want to take him out of his character.
And Mr. Hitchcock, I just want to be really clear. On your direct examination, you said safety always comes first on your set, right?
That is correct.
Your Honor, I'm going to read portions of Mr. Matz's deposition onto the record.
Go ahead.
In Mr. Matz's sworn deposition, he was asked the following question and gave the following answer. Question: you said Avery takes method acting too far. How so? Answer: in South by Southwest, one actor was playing a spy who had been captured for a year. The woman was already slender, but Avery said she needed to lose weight for authenticity. Avery wasn't happy until she looked gaunt, unhealthy, once she collapsed on the set from dehydration. In To Catch a Crook, one of the A-listers didn't want to do their own stunts. Avery was relentless. You are playing a man who isn't afraid of death. How can I put you in this role if you are afraid to get wet? The actor gave in, did the stunts, and threw up as soon as Avery called cut. Question: what was the stunt the person was afraid of? Answer: jumping out of a moving car to fall 80 feet into a river. Question: how do you know about these two examples? Answer: I saw them firsthand. No further questions for this witness.
Redirect.
Yes, Your Honor. May I proceed?
Yes.
Mr. Hitchcock, do actors have a choice as to whether or not to use method acting on your sets?
Yes, of course they do.
And opposing counsel just read you something from Mr. Matz's deposition in this trial. Was Mr. Matz's recollection of the events, to your knowledge, accurate?
No, they were not accurate.
Mr. Hitchcock, how would an actor method act while playing Kurt Cobain without using heroin?
Look, method acting is an old technique that is very well respected. It doesn't mean that if you are playing a serial killer, you go and kill people. If you're playing a surgeon, you have to go and perform surgery without a license. It means you have to cultivate the inward experience of that person. And Kurt Cobain was much more than a heroin addict. He was a father. He was a musician. He was an icon. He was a husband. That's exactly why I wanted to do a movie about him. He wasn't just a heroin addict, and I wanted to help clear that up with this film. So there's plenty of ways to cultivate that inner experience without putting yourself in danger.
Thank you, Mr. Hitchcock. No further questions, Your Honor.
And Ms. Goja, can this witness step down?
Yes, Your Honor.
Mr. Enriquez?
Yes, Your Honor.
Mr. Hitchcock, thank you. You can step down. Any further witnesses for defense?
No, Your Honor.
And defense rests?
At this time, yes, the defense rests.
And I believe we've already taken care of exhibits. I don't think there were any new exhibits that were identified during the course of the defense's case in chief, correct?
No, Your Honor.
Okay, then we're due for another 5-minute recess for counsel before we start closing arguments. So members of the jury, since I now have been reminded that some of us are in different time zones, I'll see you folks back at 45 past the hour, 45 past the hour.
May we have a time check from the bailiff, Your Honor?
And while the bailiff does that, our jurors can stay in this room. You don't need to go anywhere.
Okay, great.
You can stay right here, and we'll just all turn off our cameras for 5 minutes, and then we'll have the closing arguments. Sorry, Judge Lucky. Thank you.
No, not at all. I appreciate it. And Mr. Capacious, could we get a time check, please?
Of course. Plaintiff has used 41 minutes, 52 seconds. So that leaves 18 minutes, 8 seconds for the plaintiff. Defense has used 41 minutes, 38 seconds. So that leaves 18 minutes and 22 seconds.
Thank you, sir. All right, we'll see everybody back in 5. All right, and once we have all our jurors, we'll get started with jury instructions and then closing arguments.
Jurors, if you could do me a favor and either turn on your video or send me a chat, it can be a direct message, just so that we know that you are back and ready to proceed. I'm just going to cross check. I think there's one or two jurors I still need to hear from. So one moment, please.
Of course.
Yeah, once again, if you're a juror, please either turn on your screen or just indicate in the chat that you're here. That way we know everybody's here ready for closing arguments. We don't want anybody to miss the closings.
And while we're doing that, it's so great to see you. In real life, I get to spend so much more time with my jurors before the trial starts. So it's nice to see everybody.
Your Honor, I believe we are ready to go.
Outstanding. Then I'll steal the bailiff's thunder a little bit and recommend that people switch to speaker view. But before we're going to get to the closing arguments, we're going to do the most exciting part of the case, where I read you the jury instructions, which is the law that you will apply to the case. And after that, we'll hear the closing arguments from the attorneys.
We can turn off our videos, jurors. Thank you.
And Your Honor, just the reminder about the two stipulations.
I actually wrote them into the instructions. Yes. And this is the version that I prepared.
Amazing. Thank you, Your Honor.
Members of the jury, it is your duty to determine the facts from the evidence and apply the law to these facts. Evidence consists of witness testimony and exhibits the court received. Opening statements and closing arguments are not evidence, and you should disregard any argument made by the attorneys not based on the evidence. You must disregard testimony and exhibits the court has excluded. Evidence received for a limited purpose must be considered only for that purpose. The parties have agreed that Exhibit 13, the article "What You Need to Know About Heroin," is a respected medical authority. You should consider all evidence in light of common sense and your own experience in life. Only you are the judges of the witness's credibility and the weight to give to their testimony. You may consider the witness's ability and opportunity to observe, their memory, their manner while testifying, any interest, bias, or prejudice they may have, and the reasonableness of their testimony in the light of all the other evidence in the case. When a party has a burden to prove an element, it must prove that element is more likely true than not true. The plaintiff had the burden of proving that Ernest Ayers' death was caused, at least in part, by the defendant's negligence. For purposes of determining liability, the actions of Avery Hitchcock are imputed to the defendant, and the actions of Chandler Matz are not. The defendant had the burden of proving that Ernest Ayers' death was caused, at least in part, by Ernest Ayers' own negligence. Negligence is a failure to act in a way that a reasonable person would under the same circumstances to prevent harm to themselves or others. A person's negligence caused a harm if, one, the harm would not have occurred but for the negligence, and two, the harm was reasonably was a reasonably foreseeable result of their negligence. A harm may have more than one cause. If you find that Ernest Ayers' death was caused by both the defendant's negligence and Mr. Ayers' own negligence, you will be asked to apportion liability between those two causes. Your apportionment must total 100%. And with that, we'll turn it back over to the attorneys for their closing arguments. Again, I would suggest that everybody put their screens onto speaker view, and we'll start with plaintiff's closing.
May I proceed, Your Honor?
Yes.
The defendant handpicked an unknown, vulnerable actor he knew had a history of heroin use, supplied him with heroin, and coerced him into using it, and did nothing as he faded away right in front of him. Members of the jury, the way you will reach your verdict is by filling out a form called the verdict sheet. The first question on this form asks, was Ernest Ayers' death caused, at least in part, by Hitchcock Studios' negligence? The answer to this question is yes. I want to be very clear, members of the jury. You do not need to find that the defendant physically held Ernest down and injected Ernest with heroin himself. This is not a murder trial. This is a negligence case. And in a moment, the judge already instructed you that all we had to do was prove that it was more likely than not that the defendant's negligence was a cause in Ernest Ayers' death. And we met our burden because the evidence has shown that the defendant did not behave in a reasonably careful way. Not only did the defendant have a legal obligation to use reasonable care, but they also guaranteed Ernest that Hitchcock Studios would provide a safe set for him to work on when their CEO signed this contract. Make no mistake, members of the jury, Hitchcock Studios is legally responsible for the actions of their owner and their CEO, Avery Hitchcock. And the defendant, through the actions of their CEO, was not reasonably careful in 3 ways. Avery Hitchcock coerced Ernest into using heroin under the guise of method acting, gave Ernest heroin and set him up with a heroin dealer, and then watched Ernest deteriorate on his set and did absolutely nothing about it. So let's start by talking about how we know the defendant coerced Ernest into using heroin. To ensure that he had an actor that would listen to his demands, he wanted someone inexperienced and easily manipulated. As he confessed to Chandler Matz, when they're young and unknown, they have to listen to you. The defendant knew he had the power to make or break Ernest's career, and because of that, Ernest would have to do everything he wanted. Now, not only was Ernest young and inexperienced, but he was also previously addicted to heroin, and the defendant knew this. Mr. Hitchcock first learned of Ernest's heroin addiction in July of 2018 from his friend and talent agent, Carrie Bricker. Miss Bricker specifically asked Ernest's agent 3 questions about Ernest. Can he act? Can he sing? And does he suffer from a drug addiction? And Mr. Hitchcock, knowing about the struggle, knew Ernest would be susceptible to that very same heroin use again. So he signed that contract, and after breaking Ernest down and forcing him to reshoot that same scene 62 times over and over and over in front of the whole cast and whole crew, offering absolutely no feedback to him, he left a couple things in Ernest's trailer to inspire, to remind him of who he was playing. He left a syringe full of heroin, the article titled "Talk Screen, Cobain High on Heroin at Time of Death," and a note. Which brings us to our second point. What is the evidence that the defendant gave Ernest heroin? Jack testified that Ernest found a note from the defendant with a syringe of heroin in his trailer. Now, the defendant admits to writing this note, but denies giving Ernest heroin. Members of the jury, it's your job to decide who to believe. So let's talk about the events. All of the evidence tells us must be true, and which version of events flies in the face of your common sense. Let's start with a note. The defendant admits he wrote this note, but claims that Ernest asked him for marijuana and the defendant gave him this inspirational note with a number to call for someone who was going to sell it to him. But that makes no sense because Ernest doesn't smoke marijuana. We know he was sober. That autopsy the defense kept making a big deal of, there's no marijuana on that. And if he wanted to smoke, it's legal. He can Google it. He can ask Siri to find him a marijuana dispensary near him. He doesn't need to ask his boss to find him marijuana. In fact, no one would ask their boss where to find drugs. What does make sense is Ernest's version of the events. Ernest told Jack the defendant left this note with heroin in his trailer on June 5th. That note instructed him to call this number. This is an instruction from his boss that he was obliged to follow. And Ernest did follow instructions. And we saw that through those phone records. He followed the instructions of the defendant. The problem is those instructions killed him. Now let's talk about the ways we know the number on that note is for a heroin dealer named Barry. Barry uses a burner phone. He's what Hitchcock calls discreet. And the defendant, who's used his services for 5 years now, doesn't know his last name. You don't need to be discreet and use a burner phone if you're distributing legal substances. You need to be discreet and use a burner phone when you're distributing illegal substances like heroin. Now, Mr. Hitchcock claimed today on that stand he had an address for Barry. But that can't be true because Barry has completely disappeared. The defense can't find him. We can't find him. The LAPD can't find him. That's not a coincidence, members of the jury. It's because Barry supplied the heroin that killed Ernest. And if he were a legitimate businessman selling legal marijuana, he would have no reason to hide. He would come into court today and testify for the defendant. The fact that he's missing tells us he is the defendant's heroin dealer. Now, we know that the defendant also paid Barry for that heroin. He set them up on June 5th, the exact same day Ernest told his husband he thought Mr. Hitchcock left heroin in that trailer. His texts say, "I gave one of my actors your number, take care of him. I will cover the money." Recall how Avery Hitchcock testified in court today, how he claimed that he didn't even know what a burner phone was. Everyone knows what a burner phone is. And that's not all he couldn't recall, though. He couldn't recall what he told his attorneys about Barry. He couldn't recall if he gave an address. He couldn't recall because he doesn't remember how much he wanted to forget. He swore to you today that safety comes first on his set. But recall the sworn testimony I read in about Chandler Mathis, his sworn deposition that said Avery made people jump off of bridges and vomit from stunts. How Avery made an actress starve herself to the point of collapse, and he still claims his set is safe. Safety doesn't come first on Mr. Hitchcock's movie sets. His movie does. Members of the jury, you and only you get to decide questions of credibility in this case. You get to decide which testimony to believe. You can choose to believe everything a witness says. Some things you can choose to believe none of it. And Mr. Hitchcock today has proved he's a witness where you should believe nothing. Now, if you decide, members of the jury, that the defendant set Ernest up with that heroin dealer named Barry, it means the defendant is negligent. No reasonable director would connect their lead actor, or any actor for that matter, with a heroin dealer. But let's talk about that third way the defendant failed to use reasonable care. Even if the defendant didn't give Ernest heroin, the defendant is still negligent because he knew his lead actor was using life-threatening, illegal drugs on his set to play the lead role in his movie and did absolutely nothing about it. Now, the defense made kind of a big deal today in their opening about the autopsy report, but members of the jury, you can see that for yourself when you deliberate. They said that the wounds were up to 5 days old, so he must not have used. But members of the jury, that doesn't mean he wasn't using heroin the entire time, because common sense tells us that wounds heal. So the defense also talked in their opening today about that Mr. Hitchcock couldn't prevent what he couldn't see. But let's talk about what they saw. First, we know Avery Hitchcock must have known Ernest Dyers was on drugs or using heroin because everybody who saw Ernest thought he looked like he was using heroin. Jack told us that Ernest looked and sounded exactly like he did when he was using heroin in 2016. Chandler Matz told us he looked awful on set, both on and off camera. The defense insisted in their opening that Delaney Gold Diamond not once never witnessed any concerning behavior. But even Delaney Gold Diamond, who was paid $100,000 by the defendant, had to admit today that she thought Ernest looked tired. Recall how she testified. Recall how at the first question of her cross-examination, she couldn't remember anything. She couldn't remember who Carrie Bricker was, despite remembering everything just a second ago when her attorneys asked it. How even in spite of that, she seemed to remember that his eyes looked empty. And she didn't even see him for any more than those 3 hours. But let's talk specifically about what Mr. Hitchcock saw. The defendant himself admitted on the stand today that he recognized Ernest's behavior as that of someone using heroin. And he knew that Ernest would disappear for long periods of time twice a day. Members of the jury, you know that Ernest was using heroin because you saw it yourself. The defendant admitted that Ernest was wearing no makeup in this scene to look strung out. He looks like this because he is strung out. And we heard today that he looked like this both on and off camera. A reasonably careful director would have been concerned. Anyone would be looking at this type of behavior. And we know the defendant actually knew that Ernest was on heroin because Chandler Matz told him Ernest was using heroin. But the defendant, he didn't care. All he said was, well, Kurt Cobain used heroin. Followed by, how does he look on camera? Then after that, what do we know the defendant said to Ernest? Just a little bit longer. You are Kurt. That's not what a reasonably careful director would respond. There's nothing reasonable or careful about it. He wasn't concerned about Ernest's safety. He didn't pull Ernest aside to talk. He didn't give Ernest a break. He didn't direct Ernest to a medical staff or a mental health professional or an addiction specialist. He didn't halt production despite knowing he has an obligation to maintain safety on set for his actors. They didn't do a single thing to be reasonably careful. Instead, the defendant turned a blind eye when Ernest went late or was missing on set, because according to the defendant, when an artist is performing at that high of a level, you just don't question it. He wasn't concerned because the movie was going to be a complete success when he got a dangerously authentic performance of a man on drugs by a man on drugs. So the answer to that question we talked about on the verdict sheet, that's yes. Let's talk about question 2. Question 2 says, was Ernest Ayers' death caused at least in part by Ernest Ayers' own negligence? And the answer to that has to be no. Once Ernest used that first syringe of heroin on June 5th, which he did in the face of overwhelming pressure from his powerful boss and his own past addiction, it was no longer his choice. You'll read that heroin fact sheet, and heroin addiction starts as early as the first use. And people with a history become even more susceptible. But if you do decide that Ernest Ayers is partially to blame, you'll be asked to assign percentages of fault to Ernest Ayers and to Hitchcock Studios. And when you're considering what percentages to give, remember this. At most, Ernest made one bad choice in a moment of weakness. And after that, his addiction took over. But I want you to think about every single action the defendant took to make Ernest get to a point where he was using heroin regularly. Here are all the calculated, irresponsible choices the defendant made that caused Ernest Ayers' death. Think about this list. Think about all of the things the defendant, a famous Hollywood director, the CEO of a giant movie studio, could have done, should have done, and failed to do to keep Ernest safe. If they were really as sorry as they kept saying over and over and over, they wouldn't ask you to blame Ernest for his own death. At the end of the day, the only person who had the power here, who had the power to keep Ernest safe and away from his addiction, was the defendant. And he abused that power, and it led to Ernest's death. At an absolute minimum, the defendant is 90% responsible. It isn't Ernest's fault. The day he died, Ernest was in the home the defendant provided, on the couch the defendant supplied, behind the door the defendant paid for. Members of the jury, if there were a way that you could give Jack Ayers perfect justice, give him his husband back, erase the moment he walked in and found Ernest's body dead, covered in his own vomit next to a spoonful of heroin and a syringe, that is the option Jack would choose every single time. But that perfect justice just doesn't exist. All you can do is find Hitchcock Studios liable. Members of the jury, you and only you have the power to right this wrong and do justice in this case. For Jack, for Ernest, and for that corporation. Find Hitchcock Studios liable. Find Ernest Ayers not liable. Thank you.
Thank you, Ms. Goja. And closing argument for defense.
Yes, Your Honor. May I proceed?
Anytime you're ready.
At home, on a couch, behind a closed door, that's where Ernest Ayers spent his last moments. Members of the jury, when you're an addict, you become a slave to a substance and you're unable to stop without help. When you love an addict, watching that person self-destruct from their addiction is heartbreaking. Unfortunately, when Jack Ayers lost his husband, someone had to be blamed. And so he pointed a finger at Avery Hitchcock and Hitchcock Studios. However, today, members of the jury, you learned that unbeknownst to Mr. Hitchcock, Mr. Ayers was an addict long before Mr. Hitchcock discovered him. And when Mr. Ayers was faced with the stress of his newfound success, his sobriety couldn't hold up under the pressure. And so at home, on a couch, behind a closed door, Mr. Ayers chose to inject a lethal dose of his demon. And there's nothing that Avery Hitchcock or Hitchcock Studios could have done to predict or prevent it, because you cannot predict what you cannot see. As a judge instructed you, it is the plaintiff's burden to prove to you that it is more likely than not that Hitchcock Studios acted unreasonably and caused Mr. Ayers' death. But if they fail to do that, as they have today, then Hitchcock Studios is entitled to a verdict in their favor. And just like my co-counsel promised you at the beginning of this trial, the plaintiff has failed to state their case for two reasons. First, that Hitchcock Studios could not have foreseen Mr. Ayers' overdose. And second, that it was Mr. Ayers' own unfortunate and unforeseeable choices that led to his overdose and ultimately his death. So let's take a look at that first point, that Avery Hitchcock and Hitchcock Studios could not have foreseen Mr. Ayers' overdose. You heard testimony today about Mr. Ayers' addiction in 2016. The plaintiffs themselves characterized it as a disease. And then they spent a lot of time trying to prove to you that Mr. Hitchcock knew about this prior addiction. Jack Ayers said they told him at a lunch. Mr. Hitchcock told you that didn't happen. The plaintiff also tried to get you to speculate about a conversation between Carrie Bricker and Delaney Gold Diamond where they discussed Mr. Ayers' addiction. But to be clear, you did not hear any evidence about a conversation between Carrie Bricker and Mr. Hitchcock where they discussed Mr. Ayers or his addiction. The plaintiff did not bring you that proof. So who do you believe? Well, ultimately, members of the jury, it doesn't matter. Mr. Hitchcock told you himself that he would have cast Mr. Ayers anyways had he known, because Mr. Ayers was a brilliant actor who had that tortured artist look like Kurt Cobain. Yes, he was unknown in the movie industry, like the plaintiff keeps telling you, as any actor is when they start off. But he was a talented actor, and he was trained at one of the most prestigious schools in the world. So why is it so important to the plaintiff to convince you that Mr. Hitchcock knew about Mr. Ayers' addiction? Well, because they think it means that Mr. Hitchcock should have foreseen that Mr. Ayers would use again. But knowing someone's past doesn't mean you can predict their future. Mr. Hitchcock couldn't have foreseen that Mr. Ayers would throw it all away and risk his newfound success. The plaintiff also has to prove to you that Mr. Hitchcock caused Mr. Ayers' overdose. They're trying to convince you that Mr. Hitchcock wanted someone to method act by using heroin. They even go as far as to claim that he supplied the heroin. Take a minute to think of those claims. Not one witness who came in today could tell you that Mr. Hitchcock actually told or even suggested that Mr. Ayers use heroin for the role, or that he gave Mr. Ayers the heroin. Not one. What you've heard today, members of the jury, are a lot of assumptions, speculations, and beliefs, but no proof, because using illegal drugs is not method acting. So let's talk about what method acting is. You heard it from Mr. Hitchcock. You even heard it from Chandler Matz. It's where a character identifies with the inner motivations, where an actor identifies with the inner motivations of the character that they're playing. It's not nefarious or evil. The method has been around for forever, and it has been used responsibly by actors for forever. Now, Jack Ayers testified today that he heard Mr. Hitchcock tell his husband, "I want you to method act." And he knew who Kurt Cobain was, so he assumed that Mr. Hitchcock wanted Mr. Ayers to use heroin for the role. Members of the jury, as Mr. Hitchcock pointed out, if you're going to play under the plaintiff's version, if you're going to play a heroin addict, you gotta shoot heroin. If you're going to play a surgeon, you gotta go perform surgery. If you're going to play a serial killer, well, you gotta go start killing people. If that sounds outrageous to you, members of the jury, well, it should. So what do they bring to you as proof that Mr. Hitchcock wanted this kind of method acting? Well, they point to a text message between Mr. Hitchcock and Barry. Now, Mr. Hitchcock told you all about Barry. He told you that he gave Mr. Ayers Barry's phone number, but he gave Mr. Ayers Barry's phone number because he was stressed. He told Mr. Hitchcock he was stressed. Their idea that Mr. Hitchcock wanted someone to method act by using heroin simply makes no sense. Heroin users don't show up for work. Mr. Ayers was missing auditions in 2016. Heroin users are not perfect scene partners, as Mr. Matz described Mr. Ayers. They don't know their lines. Heroin users are unpredictable. And that's why the director of a major motion picture would never feed his lead actor an illegal and dangerous drug because it makes that actor unpredictable. It doesn't make sense from an ethical perspective, and it doesn't make sense from a business perspective. If you have to shut down production because your lead actor isn't functional or worse, well, everything is lost. An experienced director like Mr. Hitchcock would not take that risk. And the plaintiffs claim that a director would demand this kind of life-threatening dedication to a piece of work is outrageous, untrue, and unproven. So what's left for the plaintiff? Well, they have to show that Mr. Hitchcock should have known that Mr. Ayers was using, and he should have taken steps to stop it. They tried telling you there was sign after sign that Mr. Ayers was struggling with his addiction while he was filming. But what were these signs? That he was clutching his stomach, that he was scratching his body, that he was staring off into space, that he looked like he was high on heroin in a scene where he was playing a character that was also high on heroin. A movie scene, members of the jury. Every single symptom that Mr. Ayers exhibited was consistent with that of a heroin addict because he was playing a heroin addict. That was his job. One that Mr. Matz said he was great at. Now, after Mr. Ayers' death, Mr. Matz told you that he had some concerns and that he told Mr. Hitchcock about these concerns. Mr. Hitchcock told you that didn't happen. Because let's assume that Mr. Matz is right anyways. What would that mean? Remember the autopsy report, members of the jury. It didn't come from a plaintiff's witness. It didn't come from a defense witness. It's simple, cold, scientific fact. It reads, wounds range from appearing fresh to potentially up to 5 days. Now, the plaintiff points that they don't know about when wounds heal, but to be clear, you heard absolutely no evidence about that. That was pure argument. And as a judge instructed you, argument is not evidence, and the plaintiff's counsel is not an expert. So I point you to the medical authority that is evidence here today. Wounds range from appearing fresh to up to 5 days. That's what it says. So June 16th was the earliest possible date that Mr. Ayers could have injected heroin. Now, Mr. Matz told you that he told Mr. Hitchcock about his concerns on June 10th, around that time. Now, what was Mr. Hitchcock to do at that point on June 10th? Ask Mr. Ayers if he was using, demand he take a drug test, make him strip down to check for needle marks? Had he done that, he would have found nothing. If he had checked with Mr. Ayers on the 10th, the 11th, the 12th, the 13th, the 14th, the 15th, the answers would have been the same. Mr. Ayers would have said, no, I'm not using. And he'd be telling the truth. A drug test would have come up negative, and Mr. Hitchcock wouldn't have found a single needle mark on Mr. Ayers' body. And what was Mr. Hitchcock reasonably to do at that point? Follow him around? Put a tail on him? Follow him home? Yes, he provided the home for Mr. Ayers, but what should he have done? Moved in with him? Members of the jury, you cannot predict what you cannot see. And it is unreasonable for the plaintiff to insist that Hitchcock Studios should babysit their lead actor with a problem they were unaware existed. Mr. Ayers hid his relapse, and he hid it well. He hid it from his agent, Delaney Gold Diamond. He hid it on his thighs. He hid it under his long sleeves, and he hid it behind closed doors. He hid it in his home. And no one was any the wiser before it was too late. Which brings me to my second point, that Mr. Ayers' unforeseeable choices led to his relapse and ultimately his death. We also have a burden today because we are presenting to you what's called an affirmative defense. In order to meet our burden, we have to show to you that Mr. Ayers acted unreasonably and caused his own death. Now, let's be clear. Hitchcock Studios recognizes the tremendous loss that Mr. Ayers has suffered. We understand why the plaintiffs are angry. But the judge will tell you that under the law, tragedy is not enough to blame someone else for a person's unreasonable choices. The chooser is to blame. When Mr. Hitchcock gave Mr. Ayers the role of a lifetime, he knew it would be his big break. The plaintiff's position that Mr. Ayers was faced with an impossible choice simply doesn't hold, because a tough choice is still a choice. He thought he could handle the stress of a major production under a huge director, but he soon began to unravel. Mr. Jack Ayers told you that from the very first day, Ernest Ayers started to become stressed. He started becoming emotionally and physically sick. But what Jack Ayers was witnessing from his apartment in New York was actually not heroin, but Mr. Ayers' stress initially starting to take hold. Like the plaintiff told you, prior addicts are particularly susceptible. It was this stress, this self-imposed pressure to be perfect that led to Mr. Ayers' relapse into heroin. Nothing in his life had prepared him for this. So if he was stressed in 2016, when his career had barely a pulse, you can only imagine how stressed he was when the cameras were rolling and all eyes were on him. And so he turned to what he knew. He chose heroin for 5 days. He chose to get the drug. He chose to get the syringe. He chose to fill that syringe. He chose to inject the needle in his thigh. He chose to push the plunger. He chose not to get help. He chose to hide his track marks, and he chose to inject a lethal dose right as help was on its way in the form of his spouse, Jack Ayers. And that last choice, members of the jury, on June 21st, cost him everything. It was Mr. Ayers who made the dangerous choice to shoot heroin alone, at home, out of sight. Now, in a moment, you will be asked to complete a verdict form, and the plaintiff's counsel has walked through this with you, but I'd like to revisit it once more. The first question asks, what was Mr. Ayers' death caused, at least in part, by Hitchcock Studios? Based on the evidence that you've heard today, you know that Hitchcock Studios did not cause Mr. Ayers' relapse. So we ask you to put a no right there. But you also learned that Mr. Ayers made a series of unforeseeable and unreasonable choices. So based on those decisions, we ask you to put a yes on question number 2. Now, just below that, you're asked to assign a percentage of fault to each party. Based on the evidence that you've heard today, we ask you to assign a 0 to Hitchcock Studios and 100% to Mr. Ayers. Mr. Ayers had good intentions when he took on the role of Kurt Cobain. He wanted to be a star, but when the pressure grew too Great, he made the very bad choice to turn to heroin for comfort. And it was a bad choice. It was a negligent one. Return a verdict finding Hitchcock Studios not liable.
Thank you, Ms. Rhodey. Is there any rebuttal by plaintiff?
Yes, Your Honor. May I proceed?
Yes.
Members of the jury, I want to be absolutely clear that the autopsy that you saw today, we agree. But opposing counsel isn't an expert on flesh wounds. They didn't call an expert on wounds or a doctor. They can't tell you that all wounds that Mr. Ayers sustained over a 2-week period would show up in an autopsy. No, members of the jury, we all know that wounds heal. And we all know that Mr. Ayers started using heroin on June 5th. But I thought of something else that I found a little bit interesting. They claim that Ernest was such a good actor that one of the most famous directors of all time couldn't figure out when Ernest was acting and when he was really using heroin. But that can't be true because Delaney Gold Diamond, the defendant's own witness, came up on that stand today and she contradicted the defense's whole story. She told us that the moment they called cut, Ernest looked completely normal. He couldn't have been method acting all the time. It cannot both be true that he was always method acting and high on heroin, and everyone thought he was high, and also looked totally normal. But the defense said one more thing that had me thinking. She said, had Hitchcock checked, they would have known in those days leading up to his death. The problem, members of the jury.
It's excuse me, let me get my camera on. It misstates my argument, Your Honor.
So members of the jury,
I think you're.
give me just a moment. Are you saying that I'm muted?
Your Honor.
Oh, I couldn't hear you, but I can now.
Okay. So members of the jury, in terms of the arguments made by counsel, remember that the arguments of counsel are not evidence. And in terms of whether the attorneys misstate each other's arguments, you can weigh that in how you think the arguments are appropriate to consider in your evaluation of the evidence. And Ms. Goja, you can proceed.
Members of the jury, the problem is that Avery Hitchcock didn't check. He didn't care, and he wasn't concerned at all. The only person who made a choice, the only one who made a choice was the defendant when he chose to give Ernest Ayers heroin, chose to pay for that heroin for someone he knew was a recovering heroin addict, and then chose to watch as Ernest faded away on his set. It was their apartment that they paid for, their movie, their set, their heroin, their responsibility. Hitchcock Studios didn't use reasonable care. They didn't use any care at all. And that cost a man his life. And for that, they must be held responsible. Find that corporation liable. Thank you.
Thank you, counsel. And so we will turn it over to Mr. Capacious to give the last housekeeping instructions to the jury.
Yes, Your Honor. Evaluators, at this time, please complete your ballots. Jurors, please complete your verdict forms. The links are in the email that you received. If you have any trouble finding it, please message me in the chat. And if you have any questions, feel free to message me in the chat. Just make sure that those are a direct message to me, and myself and Mr. Bernstein will get them answered. Thank you. In a moment, Mr. Bernstein and I will go to another breakout room to make sure that all of the ballots are received. And once they are, we'll return to this room for further proceedings.
I could really use the Great Seal of the State of California right now.
If you have that information memorized, Your Honor, we would welcome it.
Well, it works a lot better when I have, you know what I'll do is I can screen share it.
Yes, let's fill in the silence.
Okay, let's see if we can get a decent decent image of it here. All right, here we go. Open the image in a new tab and screen share. All right, so this is the Great Seal of the State of California, and you can tell that it's the Great Seal of the State of California because it says so right around its perimeter. The very top, what you see are a series of stars, and those represent, just as the stars on the United States flag, the states that were in the Union at the time that California became a state. Underneath that, you have the word Eureka, which is hearkening to California's literally quite rich history with the discovery of gold. The seal came about, as so many other things do with flags and seals. It was a contest, and it was actually won by a military man. And just as an aside, my sister works in the Alaska State Legislature, and the Alaska State flag has a similar history in that it was a contest, and the young man who won the contest, I believe, was like 14 years old, and he was an orphan, literally designed the state flag of Alaska from an orphanage, and that is the state flag that they use to this day. Mr. Capacious, are you here to save these people from me?
Oh, I don't know if that's how I would put it, but I do have a quick request for a couple jurors. Juror Scheinlin, were you able to find the link to the form, or would you like me to send it in the chat? And also any indication that you are currently at the computer, I guess, would be helpful.
Can you hear me? Can you hear me now?
Yes. Yes, I can.
Okay, I can't get the form that I need to go back to. Oh,
Okay.
maybe now I can.
Okay, and I can also send it to you in the chat.
I can pull it up on my email, right?
Yes, the link is in your email. It
Okay,
should be.
And do I just fill it out then, or what do I do?
Yep, you take it just like the attorneys were explaining. You take it question 1. You either say yes or no.
Yeah, I got it. Okay, let me pull it up.
Okay, you can go ahead and mute yourself while you do that, and let me know if you have any questions. And is juror Ricardo Lopez here? Or did we lose you? Juror Ricardo Lopez. Okay, well, it looks like we might have lost juror Ricardo Lopez during the proceedings. So I'm going to go back and confer with Mr. Bernstein, and we should be back in just a few moments. So thank you all for your patience.
Thank you. Okay, we'll get back to the Great Seal. So the mountains and the body of water that you see represent just mountains and water, showing that we're a seaworthy state, I guess. A lot of people think that they represent a particular mountain range or a particular, or a particular body of water. To my knowledge, they don't. What I think is interesting is in the front, we have the goddess Minerva or Athena, depending on which style of mythology you like the best. You know, if you like the OG style, then it's Athena. And if you like the cover style, then it's Minerva. And you might be wondering, well, what on earth does this Greek myth or goddess have to do with the great state of California. Anybody know, just out of curiosity? Okay, so what she symbolizes is California was, I believe, you may want to fact check me on this, but was the only state other than the original 13 colonies that came into the Union without being a territory before it was a state, or at least at that time. And so as the United States expanded to the West, most of the territories underwent some type of probationary territorial period before they were granted statehood. California, on the other hand, came in with full statehood. And I think part of it was because of the resources that California had. Mr. Bernstein, are you here to save these people?
Yes, Your Honor.
Can I say one last thing, though, since I had the buildup? So,
absolutely, please.
Athena, or Minerva, if you know the myth, sprung out of her father's head as a grown woman. So she was born a fully grown goddess or woman. And that's why she is a symbol for the state of California, is because the state of California came into the Union fully formed, so to speak, as a state. And with that, I will turn it over to the main event, and let me stop the share.
First, I want to thank Judge Lucky. Can we give him a round of applause? What an amazing job in our final round. Thank you, Judge Lucky. We appreciate it. I'll ask our bailiff to join us on screen. Kenny was one of our case authors. He was a bailiff yesterday, and he did a great job in our final. You kept him pretty busy moving people to the jury room. Don't apologize. You're zealously advocating, Ms. Goja. Kenny, nice work. Do we have any of our case authors here? Stephen or Sarah, you're welcome to join us on screen along with Kenny. I wanted to thank you. This case played 53-47 and perfect balance on our evaluator ballot. So nice work, Kenny. Okay, I know what you're waiting for. I'm going to read off the scores of the individual jurors, and then I'll give you the average. So the score indicates you're reaching for your calculators to do the average, I know. So the score indicates the liability the plaintiff achieved against the defendant. So in other words, if I say 100, that means that a juror found the defendant fully liable. And if I say 0, that means that the juror said no to question 1, no liability whatsoever for the defendant. Before the trial, last night, the two teams, and you can say where you're from if you haven't already. Plaintiff, where are you from?
We're Fordham University School of Law.
Defense?
We're Loyola Law School.
Fantastic finalists. We're thrilled to have you at the competition, and you're obviously worthy finalists. Before the final round, because these two teams had not faced, Loyola had the second best record in the preliminary rounds, and so they threw out a number. They said plaintiffs got to hit 55% to win the round, and then Fordham got to choose their side. They said, we'll go plaintiff. So they need an average of 55 to prevail. These are the scores of our jurors: 100, 0, 100, 80, 100, 100, 0, 70, 90, 100, 60, 80, 0, 50, 75, 20, 0, with a final average of 60. Fordham, you are our first inaugural champion of the verdict. Congratulations. Thank you for everybody for coming. Jurors, you are welcome to stick around. I'd love to chat with you if you want to talk, but we are going to excuse our final round competitors. They have been working hard all weekend. If you'd like to stick around and hear jury feedback, you're welcome to, but I think you have some celebration to do or some sleep to get. So congratulations to our finalists. Thank you so much to both schools, to Judge Lucky, and to our jurors. Jurors, if you want to stick around, join me on screen, but if you want to sign off, you are welcome to. Thank you, everybody.
Thank you.
Thank you so much.